I'd like to tender our apologies for starting way behind schedule, and we hope to wrap up as quickly as possible. Thank you very much. So we are starting in earnest. Today, we gather at a remarkable intersection, an intersection where justice meets enterprise, where learning meets leadership, where the courtroom meets alternative dispute resolution, where ideas become institutions and institutions become legacies. For centuries, we as lawyers have shaped the society not merely by the practice of law, but by imagining possibilities beyond the present moment. Today, we continue that tradition. Today is about arbitration. Today is about legal education. Today is about property, prosperity, and national development. Today is about the future. And so, on behalf of the chairman of the Nigerian Bar Association, Eti-Osa branch, Mr. Olariwaju Obadino, the executive committee, and the Law Week Planning Committee, I welcome you to the day 5 of the MBA Eti-Osa Law Week 2026, a day dedicated to justice and real estate, law, learning, and the business of property. I'll be the host and the master of sessions today. My name is Peter Iliangwa Gabriel, the secretary of the MBA Eti-Osa branch. Ladies and gentlemen, let us begin just as all worthwhile journeys begin. So we are going to begin with prayers, because before we engage our minds, we have to humble our hearts before God. So in that regard, I'll be calling our member, Mr. Henry Ligari, to give us the opening MBA prayer.
Thank you, sir. Good morning, everyone. Please, can we be upstanding as we take the MBA prayer? Almighty God, our Creator, we pray you to be with us in all our deliberations and to direct our endeavors so that we shall continue in humility to glorify thy name and to do that which is right and just for our profession, its members, our fellow men, and our country. Amen. Thank you.
Thank you very much, Mr. Henry. The prayer has been offered, the atmosphere has been prepared, and our minds are ready, and the conversation must now begin. So, but before we begin our conversations, permit me to recognize those whose presence adds distinction to this gathering. I recognize the presence of the Director General of the Nigerian Law School, Dr. Olugbemisola Adeshote. Please, a round of applause for that. We can do better. Apologies. The name is Dr. Olugbemisola Odushote. Apologies for that. We also recognize the presence of the Registrar and the Chief Executive Officer of the Nigerian Institute of Chartered Arbitrators, Mrs. Shola Oshodi John. A round of applause for that. We recognize the presence of High Chief Professor Ike Ehiribe. We recognize the presence of the Principal Counsel of YBA and co-solicitors, Olamide Adeleye. We recognize the presence of Prince Adeleke Ogunbowale, the MD and CEO of New Map Realtors. We recognize the presence of our own mommy, our honor, Mrs. Famobio. She's been with us from the start of the law week. The Chief Magistrate of the Eti-Osa Magisterial District. So quickly, we are going to get down starting in order not to keep us waiting, having spent much time. So, just a moment. The keynote for the first session is to be delivered by Professor Fabian Ajogu, ably represented by Mr. Oke Ekwanya, partner, Kenna Partners. Professor Fabian Ajogu, as we all know, is a man who has contributed immensely to the growth of law, to the growth of arbitration, and also to tutoring of minds. So he is billed to give us a keynote, and he has sent somebody who he has baptized with the professorial blessings to do justice to his keynote. So we welcome upstage Mr. Oke Ekwanya. A round of applause for that, please.
All right. Good morning, dear colleagues, ladies and gentlemen. I don't know about the baptism spoken about, but I will do my best to do justice to the paper. So good morning again, everyone. Thank you for taking time out to join us this morning despite the weather. And congratulations to the MBA Eti-Osa branch for putting together an exciting and interesting law week so far. I'm sure this will continue right all the way to the end. So again, my name is Oke Ekwanya. I'm a partner at the law firm Kenna. I'm here. It is my honor this morning to represent my senior partner, Professor Fabian Ajogu, OFRSAN, who is president of Nigerian Institute of Chartered Arbitrators of Nigeria and a fellow of that esteemed body. And here to speak to you today about the viability of arbitration and ADR, building Nigeria's ADR economy. So, disputes, as we know, are inevitable in human interaction across modern societies. They may be domestic, international, civil, commercial, or economic in nature. And to remedy such disputes when they arise, resolution mechanisms other than the conventional court system are often employed. One of such alternative dispute resolution mechanisms is, as we all know, arbitration. Arbitration, as we know it today, has helped revolutionize the manner in which disputes are resolved, owing largely to its efficiency in cost, time, and expertise. In many leading jurisdictions, however, such as the United Kingdom, arbitration has evolved beyond the mere dispute resolution process and has metamorphosed into a significant component of the alternative dispute resolution, ADR economy. One that generates revenue, attracts investment, creates employment opportunities, and enhances a country's competitiveness as a destination for business. For Nigeria, the development of a robust arbitration ecosystem presents a unique opportunity to position ADR as a strategic profit center that can contribute meaningfully to the nation's economic growth. As Africa's largest economy, Nigeria is well placed to become a leading arbitration hub on the continent. With increasing cross-border trade, expanding infrastructure, growing foreign direct investment, and deepening regional commercial integration under the African Continental Free Trade Area, AfTA, the demand for efficient dispute resolution is expected to grow significantly. Accordingly, by developing a thriving ADR economy, Nigeria can retain the dispute-related revenues that currently flow to foreign jurisdictions whilst attracting international arbitration business to the country. The viability of arbitration, which is why we're here today. Now, building on this foundation, it becomes clear that the viability of arbitration also speaks more broadly to the strength and relevance of ADR mechanisms as a whole. ADR, in its various forms, represents a deliberate shift away from rigid, adversarial litigation towards more cooperative, efficient, and business-friendly methods of resolving disputes. Unlike traditional court processes, arbitration is designed to be adaptable. Overly technical procedures do not bind the parties. Rather, they are guided by efficiency and practicality. After hearing both sides, the arbitral tribunal delivers a final and binding award, which is presumably enforceable both locally and internationally. This enforceability is a cornerstone of arbitration's credibility, and by extension, the credibility of ADR systems generally. Now, against this background, the viability of ADR becomes evident in its ability to address some of the most persistent challenges associated with litigation systems, such as delay, costs, and procedural rigidity. ADR mechanisms, particularly arbitration, mediation, and conciliation, provide disputing parties with alternative pathways that are not only faster, but also more aligned with commercial realities and the need to preserve ongoing relationships. From a commercial perspective, this viability is critical. Business environments thrive on predictability, speed, and trust. Where disputes arise, ADR ensures that such conflicts do not escalate into prolonged legal battles that drain resources and disrupt operations. Instead, disputes are resolved in a manner that allows parties to refocus on productivity and growth. More importantly, ADR contributes significantly to economic development. A jurisdiction with a strong ADR framework sends a clear signal to investors that disputes will be handled fairly, efficiently, and without unnecessary risk exposure. This enhances investor confidence, encourages cross-border transactions, and strengthens the overall business climate. In the Nigerian context, the development of ADR represents not just a legal reform agenda, but an economic strategy. By strengthening institutions, improving enforcement mechanisms, and promoting awareness of ADR processes, Nigeria positions itself as a competitive destination for commerce and international investments. Arbitration, as the flagship of ADR mechanisms, plays a central role in building a dispute resolution environment that supports economic expansion. The economic value of arbitration. Arbitration generates both direct and indirect economic benefits. The direct revenues arise from arbitrators' fees, institutional charges, fees for legal representation, transcription services, hearing facilities, and administrative support. Large commercial and investment arbitrations frequently involve substantial expenditures, often running into hundreds of thousands or even millions of dollars. Where such proceedings are conducted within a jurisdiction, unsurprisingly, a significant portion of these expenditures remains within the local economy. The indirect economic benefits are equally important. International arbitration proceedings generate demand for hotels, transportation, conference facilities, catering, technological supports, and a range of other professional services. In established arbitration centers such as London, Paris, Singapore, and Dubai, arbitration contributes significantly to local economies by sustaining a broad network of businesses and professionals. These jurisdictions have recognized that dispute resolution forms part of a wider legal and professional services industry, one that enhances their attractiveness as global commercial centers. Now, beyond generating revenue, a strong arbitration framework enhances investor confidence. Businesses are more inclined to invest in jurisdictions where disputes can be resolved efficiently, fairly, and independently. Consequently, an effective ADR ecosystem contributes to economic development by improving the overall investment climate and reducing the costs associated with commercial disputes. Building Nigeria's ADR economy. To transform arbitration into a profit center, Nigeria must adopt a deliberate strategy directed at infrastructure, institutional development, professional capacity, and international competitiveness. This may be pursued by some of the following steps. First, I think Nigeria must continue to strengthen its local and regulatory framework for arbitration. Recent reforms, such as the enactment of the Arbitration and Mediation Act 2023, have modernized the country's arbitration laws and aligned them more closely with international standards. Consistent judicial recognition of arbitration agreements and arbitral awards will also further enhance confidence in Nigeria as the seat of arbitration. The courts, therefore, play a critical role in ensuring that arbitration remains efficient and commercially attractive by limiting unnecessary interference and facilitating the enforcement of awards. Secondly, investment in arbitration institutions and hearing facilities is essential. Modern arbitration centers equipped with advanced technology, virtual hearing capabilities, and professional administrative supports can attract both domestic and international disputes to Nigeria. Nigeria's major commercial cities, particularly Lagos and Abuja, possess the infrastructure to become recognized arbitration destinations that can compete with established regional hubs. Thirdly, professional capacity development must remain a priority. A thriving ADR economy requires highly skilled arbitrators, mediators, counsel, experts, and case administrators. Universities, professional bodies, and arbitration institutions should accordingly expand their training programs and certification opportunities to build a larger pool of qualified practitioners. Developing specialist expertise in sectors such as energy, construction, telecommunications, maritime, and finance will further strengthen Nigeria's competitive advantage. Fourthly, Nigeria should actively market itself as an arbitration destination. Strategic partnerships with international arbitration institutions, participation in global ADR conferences, and the promotion of Nigerian arbitration success stories can all enhance the country's visibility and credibility. The objective should be to position Nigeria as the preferred venue for dispute resolution in West African and broader African commercial transactions. Lastly, mentoring from older players, considering that arbitration in Nigeria is a close-knit field. It calls for mentorship from the older generation of experts to share their knowledge and assist with the professional development of the next generation of young arbitration professionals who are set to rise. Challenges and opportunities. Several challenges must be addressed if the full potential of Nigeria's ADR economy is to be realized. Perceptions of judicial delay, inconsistent enforcement practices, infrastructure limitations, and limited international visibility continue to affect the country's competitiveness. In addition, many high-value disputes involving Nigerian parties remain seated in foreign jurisdictions, resulting in significant economic leakage. Despite these challenges, though, the opportunities are substantial. The growth of inter-African trade, increased infrastructure investments, the expansion of the energy and technology sectors, and the implementation of AFTA are all expected to generate a greater volume of commercial disputes requiring sophisticated dispute resolution services. Nigeria's large legal markets, the largest bar in Africa, its strategic geographic position, and its growing pool of ADR professionals together provide a strong foundation for capturing this opportunity. Furthermore, technological advances have lowered the barriers to entry for arbitration. Virtual hearings and digital case management systems now enable jurisdictions to compete internationally without the need for extensive physical infrastructure. By leveraging technology and innovation, Nigeria can accelerate the development of its ADR sector and extend its reach well beyond domestic disputes. In conclusion, arbitration should no longer be viewed solely as a mechanism for resolving disputes. It should be recognized as an economic asset capable of generating substantial value for Nigeria. A well-developed ADR ecosystem can create employment, attract international business, retain legal service revenues, stimulate related industries, and strengthen investor confidence. By investing in legal reform, institutional capacity, professional development, and international promotion, Nigeria can establish itself as a leading arbitration hub in Africa. The transformation of arbitration into a profit center represents more than an opportunity for the legal sector. It is a strategic economic initiative, I dare say. As commercial activity continues to expand across Africa, Nigeria has the potential to become a destination of choice for dispute resolution, thereby building a sustainable and competitive ADR economy that serves both its courts and its wider economic interests for years to come. I thank you all for listening.
We can do better, we can do better. Thank you, Mr. Oke, for the insightful presentation. You know, some speeches inform, some speeches inspire, and some alter the way we see things, the way we see familiar things. So the speech combines all three in one. And we appreciate the professor ably represented by Mr. Oke for doing justice to that topic. So to provide remarks and reflections on the presentation, it is our pleasure to invite a distinguished administrator, a legal practitioner, and a leader within the arbitration community. She currently serves as the registrar and the chief executive officer of the Nigerian Institute of Chartered Arbitrators. Ladies and gentlemen, please welcome Mrs. Shola Oshodi John.
Good morning, the chairman of the Nigerian Bar Association, Eti-Osa branch, my lords, distinguished senior advocates, esteemed members of the lower bench, and learned colleagues, ladies and gentlemen. I actually came here with a prepared speech because I was told I was going to be making a speech as well. However, I had listened to the speech from my president, Professor Fabian Ajogu, UFRO SAN, and I would, in the course of my presentation, skip a lot of the things I've heard so that we don't repeat the same things. So let me start by saying that every generation of lawyers inherits a defining challenge. For some generations, it was struggle for constitutional government. For others, it was the indigenization of our legal system after independence, or the defense of democratic institutions during periods of political uncertainty. Our generation faces a different but equally consequential question. Can law remain an instrument of justice while simultaneously becoming an engine of economic development? This question lies at the very heart of the theme of this conference today. Law as business, law as justice, profitability, ethics, and human rights in a changing world. The team invites us to reconsider long-held assumptions about the legal profession. It challenges us to recognize that justice and economic value need not exist in opposition. Rather, they can reinforce one another while supported by sound institutions, ethical governance, and visionary leadership. Few areas illustrate this better than arbitration and alternate dispute resolution. For decades, arbitration in Nigeria has been viewed principally as an alternative to litigation, a mechanism for resolving disputes outside the courtrooms. While this remains its foundational purpose, such a narrow conception understates its true significance. Across the world, arbitration has evolved into a sophisticated global industry. It generates billions of dollars annually through legal services, institutional administration, counseling, hospitality, technology, publishing, education, and professional support services. Entire cities have been transformed themselves into arbitration destinations, attracting international disputes and economic activities that accompanies them. The question before us today, as Nigerians and our country, Nigeria, is therefore no longer wider arbitration and ADR is an effective dispute resolution mechanism. The question is whether we, as lawyers, and our country, Nigeria, will harness arbitration as a strategic economic asset capable of driving growth, strengthening investors' confidence, creating employment, and advancing sustainable development. Consequently, arbitration should no longer be viewed merely as a legal process, but as a sophisticated professional service industry whose economy exists well beyond the courtroom. Whether a major Nigerian commercial dispute is held in London, Paris, Singapore, or Dubai, Nigeria exports not merely a dispute, but also substantial economic value. Legal fees are paid abroad, hotels benefits abroad, conference facilities are utilized abroad. The economic multiplier that ought to strengthen Nigeria instead strengthens other jurisdictions. This represents one of the least discussed form of economic leakage within our legal system. Today, we look at the global arbitration economy, and one can say that the world's leading arbitration centers demonstrate what deliberate policy can achieve. You look at London, Paris, Singapore, Geneva, Dubai, and Hong Kong, you will see that they each have developed arbitration ecosystems that has contributed significantly to the knowledge economics. They have successfully integrated legal excellence with technological education, hospitality, and international commerce. Government increasingly recognize that attracting arbitration business is comparable to attracting foreign direct investment. Arbitration promotes commercial confidence, reinforces contractual sanctity, and projects institutional credibility to global markets. The arbitration industry therefore generates value far beyond legal service because it also strengthens national competitiveness. What are the lessons for us in Nigeria? And I dare say Africa itself provides compelling examples. Cairo, the regional center for international commercial arbitration, has through decades of institutional competency and government support become one of Africa's most respected arbitration institutions. Its success demonstrates the importance of credibility, continuity, and international engagement. Johannesburg, South Africa. South Africa Arbitration Foundation benefits from sophisticated commercial infrastructure, matured financial markets, and strong legal institutions. Johannesburg has become a preferred venue for commercial and infrastructural disputes because arbitration there forms part of a broader ecosystem of investors' confidence. And not too long ago, we come over to Kigali, Rwanda. Perhaps this is the most remarkable example. Despite having a considerably smaller economy than Nigeria, Rwanda deliberately incorporated arbitration into its national economic strategy. Through institutional excellence and policy consistency, Kigali has become an internationally recognized dispute resolution destination. Its experience teaches an important lesson. Success in arbitration is determined less by economic size, but by strategic vision. And so when we come to Nigeria, permit me to speak about my own institute, the Nigerian Institute of Chartered Arbitrators. In the last 2 years, 2024 and 2025, NICAB had been able to administer 37 cases, valued in Naira 5,865 million Naira, and in $10 million. And so you see that in 2 years, just having 37 disputes, we have been able to manage and resolve disputes with such quantum of claims involved. And having said that, I will say that Nigeria today has comparative advantage over the other 3 centers and cities that I've mentioned, particularly Lagos. We possess many competing jurisdictions do not have, and they aspire to have. We have the largest economy. We have the largest legal profession. We have significant expertise in energy, maritime, banking, construction, telecommunication, and so on. And moreover, the commercial dynamism of Lagos as West Africa Economic Nerve Center and our modern, which we've already mentioned earlier by the keynote speaker, our modern legislative framework of the Arbitration and Mediation Act and also the National Arbitration Policy of 2024 has shown that Nigeria has what it takes to become a globally recognized seat for resolving arbitration matters. Very few jurisdictions combine and have in existence these advantages that Nigeria have. Yet, many of our disputes continue to be resolved abroad due to lack of intentionality on the part of the Nigeria and Nigerian users, Nigerians users and practitioners alike. The consequence is that Nigeria exports both legal work and economic opportunity to the disadvantage of its citizens and its economic development. Arbitration, the question was, is it a national profit center? So we use the word profit and profitability in relation to arbitration because we do not want you to have a narrow understanding of the word profitability, but rather look at it from the perspective of benefits to Nigeria and the nation in general. And the benefits operate in 3 intercoordinated levels. We have institutional benefits, professional profitability, and the national economic profitability, which has been referred to earlier by the keynote speaker. But permit me to look at profitability, ethics, and human rights in terms of arbitration and AGR practice. Some may ask whether the commercial aspect of arbitration risks undermining justice, because this has been a major one at the top burner of thoughts for legal practitioners in Nigeria. I believe this concern deserves serious consideration in the light of the place of ethics and human rights in the scheme of things. Given the state of legal practice in Nigeria in the past 2 decades, we will say that, yes, there is a reason for some doubt. But however, the legitimacy of arbitration depends upon independence, fairness, transparency, accountability, and accessibility. As a result, profit cannot become the objective at the expense of justice. Rather, profitability must be the consequence of institutional excellence. The true measure of a successful arbitration system is not merely the revenue it generates, but the confidence it inspires. Justice remains its foundation, ethics remains its compass, human rights remains its ultimate legitimacy. Arbitration and sustainability development. The United Nations Sustainable Development Goal 16 emphasizes effective institutions and access to justice. Arbitration and ADR contributes directly to these objectives. And like we all know, reduction in judicial congestion, efficient dispute resolution, enhancing contractual sanctity, amongst others. Far from competing with the judiciary, arbitration complements it by strengthening the overall administration of justice. There is a need to build Nigeria's ADR economy. In order to do this, we have to transform arbitration into a strategic economic sector. Nigeria as a nation should pursue a coordinated national strategy based upon 6 pillars. 1, position Lagos as West Africa Preferred Arbitration Center. 2, expand professional training, which we are already doing as an institute, and I believe we can do more. Invest in digital infrastructure. Strengthen collaboration among arbitral institutions. The need for it and the time for it is now. Strengthen collaborations among professional bodies and government agencies and universities, which is something the Nigerian Institute of Chartered Arbitrators had pioneered in 2017 with our Fair Babalola University, training young undergraduates as certified arbitrators and mediators. And one other area that I would like to talk about is the next generation, the need for us to begin to invest, and we've started doing that. And I say that the strongest argument for expanding Nigeria's ADR economy is the opportunity it presents for young professionals. The future arbitration and ADR ecosystem require a lot of expertise across different professional lines. But arbitration aligns perfectly with Nigeria's aspiration for youth employment and a knowledge-based economy. However, as key stakeholders, we have the ultimate responsibility to unlock these potentials by creating the enabling environment for the ADR ecosystem to thrive. In conclusion, the future of legal practice lies increasingly at the intersection of commerce, justice, technology, and sustainable development. Arbitration and ADR embodies the convergence. It demonstrates that law can generate sustainable economic value while simultaneously promoting fairness, certainty, investors' confidence, and the rule of law. We have seen this all over from Cairo to Joburg to Kigali. We have seen that arbitration is a major economic sector that supports vision, policy, and institutional excellence. We know that Nigeria possesses the market, legal talent, commercial sophistication, strategic location, among other things. But the question before us is no longer whether arbitration can be a viable practice for lawyers. The real question today is whether key stakeholders operating in the administration of justice sector, from the legal councils to the judiciary and the government, will intentionally build an arbitration economy capable of retaining legal value, attracting international disputes, creating opportunities for its young professionals, strengthening investors' confidence, and positioning itself as the undisputed dispute resolution capital of West Africa. History today teaches that nations prosper by exploiting natural resources. Nations prosper not by exploiting natural resources, but by cultivating institutions that inspires confidence. Arbitration and ADR is one such institution. It should no longer be viewed simply as an alternative to litigation, but as an alternative pathway to national development. Every dispute retained within Nigeria strengthens our legal profession and arbitration practice. Every international arbitration seated in Lagos enhances investors' confidence. Every young lawyer trained in arbitration and ADR expands our human capital. Every strengthened arbitral institution contributes to our knowledge economy. Therefore, the question before us is no longer whether arbitration is viable, but rather whether we will seize this historic opportunity to build an ADR economy that advances justice, strengthens ethics, attracts investment, empowers the next generation of professionals, positions our nation as the undisputed resolution capital of West Africa. If we succeed, arbitration will no longer merely resolve disputes. It will help build the future of Nigeria. Thank you.
We can do better, please. Ladies and gentlemen, the mark of a great presentation is that it leaves us with more questions than answer. It's not that the speakers did not do justice to what they've been asked to do justice to, but because their presentation awakens our minds. And so we move from presentation to conversation, and from keynote to collective wisdom, from one voice to many perspectives. So we are moving straight into the panel session, and every meaningful conversation requires not just participation, but a coordinator and someone who is capable of transforming multiple perspectives into a coherent symphony. To moderate this distinguished panel that we are going to call up, we are pleased to welcome Jessica Obodo Elue, an associate of Kena. Without wasting much time, may I now invite to the stage a gathering of some of the finest minds in arbitration and dispute resolution. First on my list, I'd like to welcome Olamide Adeleye, a principal counsel of YBA and Co. Solicitors. She's an experienced managing principal with a demonstrated history of working in the legal industry. She's a skilled negotiator, litigator, arbitrator, and a leader. The next on my list is High Chief Professor Ike Ehiribe. Professor is an international arbitrator and dispute resolver. He specializes in the resolution of a broad spectrum of international, commercial, sports, arts, and intellectual property disputes. You can do better by clapping for him, please. The next on my list is no other person than the person who just gave a remark on the keynote. I'm pleased to welcome upstage Mrs. Shola Oshodi John, the Registrar and Chief Executive Officer of the Nigerian Institute of Arbitrators. She is also the Vice Chairman of the Nigerian Bar Association Section on Legal Practice, Arbitration, and ADR Subcommittee. with all the cold that came with the rain, the panelists are here with a blanket of wisdom and experience to provide us with warmth. And so I will kindly implore you to pay attention. Who knows, you might gain one or two things, or maybe something may tickle your interest. So on this note, I yield. Oh, so sorry. I also invite upstage Mr. OK. Sorry, let me get the name again. Mr. OK Ekwanya, partner Kenna, who delivered the keynote on behalf of the professor. So I'll yield the floor now to the moderator to conduct the session.
Thank you so much, Gabriel. Good morning, everyone. As Gabriel rightly said, oftentimes when we have a proper speech, it opens up our minds to various questions that, need proper answers. And the theme of today's session, which is the viability of arbitration and ADR, building Nigeria's ADR economy, is one that calls for deep conversations. How can we expand, our ADR economy in Nigeria to make it to be the preferred choice? I came across a quote that mentioned that for every time parties to a dispute leave Nigeria and go outside of the country to resolve that dispute through arbitration or ADR, money is left on the table. So this panel session is going to be a ground to answer the deep questions that we might have for clarification on how we can work together to indeed build the ADR economy of Nigeria. So without wasting further time, I will dive straight into the questions. And I just want to say everyone on the panel is looking absolutely dashing this morning. Starting from Mr. Ekwaya to Mrs. Oshodi John to Prof. and then to Ms. Adeleye. It's such a pleasure to have you all here this morning. So for the first question, I will direct my first question to Mr. Ekwaya. And it's going to be a scenario-based question. So imagine a mid-sized Nigerian manufacturer. They have an annual revenue of about 500 million naira. And they are currently involved in a contractual disputes of about 18 million naira. Their lawyer has advised them to go through arbitration. They have an agreement that contains an arbitration clause. But the estimated cost, arbitrators' fees, administrative fees, counsel fees, and the venue approximately cost between 25 million to 30 million naira. That is a third of the amount in disputes. The company chooses to litigate instead. How common do you see this kind of scenarios? And does it suggest that arbitration in Nigeria has a fundamental pricing problem?
All right. Thank you, Jessica, for the question, and good morning again, everyone. It's actually, that's an interesting question. I will say that, yes, it's a pretty common phenomenon, but perhaps to modify the scenario a little bit, this typically would, or as you said, have occurred when, this would be when a dispute has arisen already. And at that stage, if you do have an arbitration clause already embedded, then you're bound by it. Whether the lawyer at that stage advises litigation, it goes to little or no issue at that point, because you are bound by your agreements under an arbitration clause. So I would say it is pretty common, because at the stage of drafting, unfortunately, some commercial parties don't appreciate the need to prepare adequately for a dispute. Nobody, of course, expects or hopes for a dispute, but it is received wisdom that you should prepare for all eventualities. And so it's typically nice, and it's good language to incorporate an arbitration clause without looking at the realities of the particular party. And then a bit further down the line, when a dispute has arisen and you're seeing the value and the potential cost of going to arbitration, it then becomes an issue. I wouldn't say it's a typically Nigerian problem. To answer the last part of your question, I think it's an integral feature of arbitration that it moves, will I say, costing for the administration of the proceedings from the state, as you would have in litigation, to the individual parties who have signed up for arbitration. So it's not necessarily, in my view, a typically Nigerian problem regarding funding. It's just a feature that parties need to be aware of and to understand that at the operative time, when they are entering into the agreement, and not really, ideally, when a dispute has already arisen.
All right. Thank you so much, Mr. Acquire. So just to trickle down that same lane just a little bit, I know that one of the selling points that we often, express about arbitration is its efficiency as to cost. But over the past few years, there's been a bit of concern about the expensiveness, how expensive arbitration has become, and it's kind of now trickled down to be presented as kind of like an irony, where parties, enter into that stage of when they want to start the arbitration proceedings, and they're taken aback by the costs that they have to cover, starting from the prices of covering arbitration to the prices of expending on the fees for their counsel. So what do you think that we can do to target essentially the pricing problem in arbitration? Or is this something that parties just need to be aware of when going into such proceedings?
Thank you again for that follow-up question. I would say it just goes, and it's a great point, fair point. Actually, a lot of people don't appreciate at the outset the costs. But I must also stress that a higher figure doesn't necessarily equate into a higher cost, if that makes sense. If you then factor in things like the time value of money and those sort of issues. So in the end, it really, there's no, I would say, one size fits all or a silver bullet that resolves all the problems. It's just something that parties need to be aware of and take whatever steps or measures that are appropriate for them at their own commercial stage, if you like.
All right. Thank you so much, Mr. Acquire. So my next question will be to the beautiful Mrs. Shola Oshodi-John, the CEO of the Nigerian Institute of Arbitrators. So my question to you is, how do you see Nigeria positioning itself to be a leading arbitration hub in Africa, considering that we are the largest economy in Africa? What steps do you think that we should take to position us to be that leading hub?
Thank you, Jessica. Well, by virtue of my position as the registrar and CEO of the Nigerian Institute of Arbitrators, I would not allow the previous question you asked, to pass me by. I will definitely respond. And my response is this: arbitration is cheaper than litigation. But when we say that, there's a caveat. And the caveat is depending on the complexity of the matter. Then secondly, yes, arbitral institutions have scales. We normally have a scale of fees chargeable, telling you this is the limit. But arbitration also has an opportunity for parties and the arbitrator to negotiate their fees. It's very important that parties know that and their counsels know that. I have come across instances where parties run to me to say, oh, talk to the arbitrator, the fee is too high. And I'm like, what we have given is a scale. But please, you can go back and negotiate. Tell him what you can pay. Because arbitration is not it's not compulsory that you must use a particular arbitrator. You have a choice. You can decide if arbitrator A is too expensive for you, you look for a cheaper arbitrator. The choice is yours. But unfortunately, in this climate, we always go for titles. because we believe that once the person has a particular title or appendage to his name, he will be able to do the job. So, like Mr. Oke has said, it's not a one-size-fits-all, and depending on which perspective you're looking at the issue of cost drop, then I can say arbitration is cheaper than litigation, particularly when you look at the number of years you have to spend in court over that same matter. Thank you. So, to my question, how do you see Nigeria positioning itself as a leading arbitration and ADR hub? First of all, let me say that Nigeria already has all the vital ingredients to be a leading arbitration and ADR hub, because we have the largest economy by population. We have a sophisticated legal profession, very important. I believe Nigeria has one of the highest number of legal professionals in Africa. We also have a vibrant commercial sector. Last week I heard about Dangotified. Nigeria is already pioneering investment in Africa with the Dangote's refinery and all that things that is doing in all the African countries. So before, we used to look for investment from abroad, but now the investment is coming from within. So when investments are coming from within, then you know that definitely there is going to be a lot of disputes, and as a result of that, we have to be prepared to handle these disputes. So the other thing you need to understand is that Nigeria is strategically located. It has access to West and Central Africa, and we can capitalize on all these advantages because the fact that we offer a jurisdiction that has efficient institutions, modern arbitration laws like the Arbitration and Mediation Act of 2023 and the recently passed, executed national policy on arbitration. And then one strong thing I want to say today is that we have judicial support for arbitration in Nigeria as of today. In the past, yes, we're struggling with that area. But today, I believe that most judges would gladly and quickly and promptly refer disputes back to arbitration where they find out there's a valid arbitration clause. And in instances, we've seen a lot of judges that are also members of professional arbitration bodies. So they have learned the ropes, they have learned arbitration, so they understand the various issues that obtain where there's a need for the judiciary to intervene and step in where there is need for them to. Thank you.
All right. Thank you so much, Mrs. Oshodi John. I have a follow-up question for you. So we have talked about the benefits and how Nigeria can position itself as a leading arbitration hub. And you mentioned something so profound as to how the roles have changed now. The investments are coming from within Nigeria more often than from outside Nigeria, which is great. So now that we know how to present ourselves, what are the biggest challenges do you think are preventing Nigeria from becoming the preferred seat when it comes to international arbitration? And how do you think, the ADR institutions and the courts can work together to improve the efficiency of same?
Thank you very much. One of the biggest challenges that we have, which a lot of other jurisdictions are doing very well, that I mentioned earlier in my paper, Rwanda, Kigali, Cairo, Egypt, AFSA in Joburg, South Africa, is that they have strong government support. The government is not only providing an enabling environment for those cities to thrive, for those hubs to thrive, but the government also is intentional about, the centers, financial support, policies. They're doing a lot. They're also going as far as ensuring that their disputes that is government related are settled and handled by those centers in their various countries, which is different from what we see in Nigeria. Arbitration is about capacity. Once you have the enabling environment, you have the strong institutions, then the other issue is you have the human capital. Do you have the experienced arbitrators to handle the disputes? And you can only gain experience when you do a task repeatedly, when you have the opportunity to handle those disputes. And so for us in Nigeria, it's the disservice to us that most of our disputes are shipped out of Nigeria at the expense of developing arbitration skills and capacity in Nigeria. That's one thing. Then the second thing that I think they need to do is there needs to be a convergence among the various arbitral institutes. There needs to be a convergence among the various arbitral institutes, and I think in this instance, the government has a role to play. And the role is what they've started with the national policy of arbitration. But we need to move beyond just a policy. A policy is just a paper. If you do not execute or implement a policy, it's as good as you never have that policies in place. So I would like to see the Honorable Attorney General and the federal government of Nigeria move the policy forward to the implementation stage and do a lot of the things they talked about: human capital, support for arbitral institutions, ensure that we have a viable and working environment, security. I understand that one of the reasons why our keynote speaker didn't come for this event was because of security issues. And so if Nigeria is really going to be a hub, okay, we need to deal with our security issues. And I finally like to say that I'd like to see I'd like to see the judiciary and arbitral institutions work closer. Arbitral institutions is not in competition with the judiciary. We complement ourselves. And so there's a need for us to bridge those gaps, to make sure that whatever we need to do, either as arbitral institutions or as judiciary, it is done in the best interest of Nigeria. And then, finally, a final point I want to leave has to do with us, legal practitioners. With due respect, today I sit here and I'm privileged and honored to sit at this position. But I want to say that members of our honorable profession has not done very well when it comes to promoting the growth of arbitration in Nigeria. By virtue of my position, I see a lot of cases come into my institution, and we are asked to appoint arbitrators. And a lot of the law firms, with due respect, that are big law firms, international, I don't know what to call them, when their clients are the claimants, they embrace arbitration wholeheartedly. They are willing to go all the way to arbitration. But when they find their clients on the other side, they kick against arbitration. They begin to file all kinds of applications, starting before the arbitral tribunal and then to the law courts. How do we want to have a vibrant arbitration ecosystem if we that are supposed to be the custodians of arbitrations are the one actually creating the problem? Yesterday, I was privileged to speak to Justice Tunde Oshodi, and I said, what do you think can be done regarding the arbitration ecosystem in Nigeria? And he said, you know what? It is not the judiciary that has a problem. It is what you lawyers bring to the judiciary that they're going to look at. And so if the lawyers begin to do things rightly, then, of course, the judiciary has no business than to do what they have to do. Thank you.
All right. Thank you so much, Ms. Oshodi John. I would say that you really captured it beautifully. So my next question will be to Prof. As we know, there is a bit of sanctity when the law is certain, and when international investors oftentimes look for, when they're oftentimes entering into contractual agreements, they always look at the certainty and the predictability of the law. So that's where my next question is going to draw from. Do you think Nigeria's current legal framework provides sufficient certainty and predictability for international investors considering arbitration in Nigeria?
Hello, can you hear me?
Yes.
Okay. Madam Moderator, thank you for the question. But before I answer the question, there are a number of matters I need to deal with. First is to thank the MBA Eti-Osa branch for inviting one to participate in this event, and to also schedule a session for us to discuss at length the viability of arbitration and ADR. This is highly commendable, and please long may it last. May I also use the same opportunity to also recognize or thank the attendees, the distinguished guests who have come here, members of the judiciary, senior counsel, lawyers, and other professionals. I commend all of you for finding the time to attend this event. So with that out of the way, may I now then condescend to my next task, which is again to thank you, Madam Moderator, for moderating the session so far, and my distinguished panelists, co-panelists for their various contributions. I also want to make the point very quickly that I endorse all the views expressed in the first and second keynote addresses that have been made by my distinguished co-panelists. Now, to the last assignment before I come to your question, I too will not allow this discussion about costs of arbitration to go unattended by my humble self. You can say I am biased. I have no shame in being biased in favor of arbitration and alternative dispute resolution. Now, when the complaint of costs is brought to the fore about arbitration, what costs are we really talking about? Is it costs of the counsel's fees or costs of the arbitral tribunal, the neutrals themselves? This is a complaint that has gained traction for a very long time in various jurisdictions, not just in Nigeria, elsewhere in the world. And it's always a complaint directed and at demarketing arbitration and ADR by those who, for one reason or the other, have a grudge or a grouse with arbitration and ADR. The first thing you'll hear is the cost. But cost as compared to what? Is it the cost of a landlord and tenant matter as against an oil and gas case? Or is it the fees of the tribunal members as against counsel? And it's because of the frequency of these complaints, I've now made it a point of duty in the last 10 or 15 years to carry with me a document from one of the most respected international arbitral institutions, which highlights the fact that in most cases that were viewed in a particular period of time, what was the largest component of the costs of the arbitration was not the arbitration itself, but the cost of counsel's fees is as high as 82%. Counsel's fees in arbitration, international arbitration, as high as 82%. Whereas the fees of the tribunal members was a mere 16%. So how come these complaints keeps on repeating itself? And as my distinguished colleague to my left said about arbitration and the time it takes to conclude an arbitration, as compared to concluding a matter or a dispute that crystallizes in the first instance between parties, goes to a high court, from the high court goes to the Court of Appeal, from the Court of Appeal goes to the Supreme Court, from the Supreme Court perhaps a higher court, whether it's a House of Lords or Court of ECOWAS. Is anyone computing the cost of all of those stages and the fact that at each stage, counsel is changed? Who again will charge more fees in order as they will say, protect the right to a fair hearing of a particular party who has a decision he or she is disgruntled with. And as my co-panelist made mention, arbitration is not is not cast in stone. If there are issues about cost, then there's that opportunity to negotiate. And it's for those who are representing parties to look for those who are able to price or charge a competitive rate to represent parties in arbitration. Just recently, it is in the public domain, someone a certain barrister, Queen's Counsel or King's Counsel, who represented Nigeria in the famous, as it were, P&ID case against Nigeria, has had his or her fees challenged. he was charging £2,000 per hour. Query, what were the lawyers representing the Nigerian party looking at? They ought to have shopped around for someone who would have charged less, £2,000 an hour. And of course, those fees of that council are being slashed or being challenged in the costs court in the United Kingdom. So I hope that sinks in as far as cost is concerned, and we should stop this habit of criticizing or complaining about arbitration on cost-related complaints. So that's that. Now back to your question, which is again on whether the legal framework in Nigeria is certain or provides predictability. Well, I must commend the Nigerian jurisdiction for, at long last, amending the Act, the Arbitration Act, by virtue of promulgating the Arbitration and Mediation Act of 2023. That has gone a long way to ensure that the arbitration ecospace is now in line with international best practices and in line with international conventions that govern the arbitration and ADR ecospace. There's a lot to be said for that, and I can assure you that there's a lot of certainty and predictability that is embedded in that act. Time will not allow me to go through the various provisions, but I can assure you from what I get to hear and the feelers out there, there is a lot of enthusiasm, renewed enthusiasm by those who would prefer to resolve disputes in the Nigerian jurisdiction because of that act. And even before that act was promulgated, don't forget that the Chief Justice, a former Chief Justice in this jurisdiction, had also promulgated a practice direction. I think it was 2017, if I'm not mistaken. Sorry? Exactly. I'm reminded of the name of the Honorable Justice, and Justice Walter Onogen, who was the Chief Justice of Nigeria at the time. It was that practice direction that, more or less directed most disputes that had an arbitration clause should first and foremost be dealt with by arbitration instead of the usual practice of running to the courts to challenge the arbitral process. So both either by way of legislation or by way of practice direction, there's now a lot of certainty, increased certainty, and of course there's a lot of work to be done, because not just the law alone, is a mindset and the attitude of the legal profession which has to change. And I think, and I believe from what I'm hearing and what I'm seeing, that there is gradual improvement, but again, there's a lot of room for improvement. Thank you very much.
Thank you so much, Prof. Thank you very much for your well-reasoned answer to the question. And thank you so much for highlighting the fact that in recent times, there has been a lot of regulatory development when it comes to arbitration in Nigeria, one of the foremost one being the advent of the Arbitration and Mediation Act 2023. So the next question would be to Ms. Adile. So, Ma, from your experience as an arbitrator, with many years of experience at that, what do you think are the biggest factors that influence parties when deciding between litigation and arbitration, apart from the general factors in which we know, like costs, expertise, and the fact that they're able to preserve their confidentiality?
Right. Thank you very much. All protocols observed. I would also like to add my contribution to the expensiveness, the perceived expensiveness of arbitration. And coming from another angle, knowing fully well that when it comes to arbitration, arbitration is really different from litigation in the sense that litigation tends to produce winners and losers. But arbitration comes from the angle of resolving disputes and salvaging long-time contractual relationships. Now, there are some of those contractual relationships that you cannot put a value to. So how expensive can arbitration or ADR be? And then also there's the erroneous perception that, arbitration is, because of this erroneous perception of the expensiveness of arbitration, a lot of small businesses don't even think of arbitration or ADR as a way of resolving their disputes. They think ADR arbitration is for the big corporations, which is really erroneous. But in a properly structured ADR system, small businesses, SMEs, can also equally benefit from alternative dispute resolutions. Okay, so going to my question from my experience. So there are so many factors that influence parties when deciding whether to choose arbitration over litigation. And I'll start from where I finished. Litigation is adversarial in nature. Arbitration tends to preserve the relationship. So arbitration is efficient in that it salvages, whatever relationship these parties have built over time. It preserves that. Arbitration, then I will talk about the speed of arbitration as well. It gives the parties the opportunity to determine the time frame within which their disputes can be resolved. And it can be resolved efficiently as well when they engage experts. So, for example, in telecommunications, construction industry, in oil and gas, that's why you would discover that a lot of the IOCs, would rather go in for arbitration or ADR rather than go to courts. You hardly see them in courts because also it preserves the confidentiality of the case, thereby also preserving or preventing reputational damage, which is which is a key factor for big corporations, big organizations, international organizations. And so I've talked about the speed and efficiency, confidentiality, and the party autonomy as well. Parties can actually determine who their arbitrators are. They can actually determine the seat of arbitration. They can actually determine the rules of arbitration. And so it gives them a lot of confidence already, even before going into the into arbitration. Already they have confidence because they have confidence in the whole process because they have been a part and parcel of the selection process. And then you already mentioned expertise, and also enforceability is another thing that I would like to also mention. Awards are easier to enforce, and also because of the global framework created by the New York Convention, to which Nigeria is a signatory. So awards are very easy. They are easier to enforce than court judgments. And yeah, so that's it for me.
All right, so thank you so much, Mr. Dele. I think you mentioned something so profound that really highlights one of the reasons why parties enter into arbitration in the first place, to conserve and preserve the contractual relationship. It's not adversarial. Parties are, at the liberty to choose the mechanisms on how they want that dispute to be resolved. And I think that that's one of the assurances that arbitration really provides, that, ends up helping with the economic growth of a country, because when contractual disputes end up in courts, we know that there's a lot of backlog in the courts, but the arbitration gives a specific time frame that helps to provide some certainty to the parties, which helps to drive down our point here that arbitration is truly a gem that can really help with the economic growth of Nigeria. Okay, so my next question would be to Mr. Ekwaya. So the question goes that there is a notable preference in Nigeria for ad hoc arbitration over institutional arbitration. Some attribute this to cost, others to distrust of the local institutions. What explains this preference, and if it is ultimately helpful or harmful for the development of Nigeria's ADR ecosystem?
All right, thank you once again, Madam Moderator. The issue of costs again. So I don't want to be eaten up by my co-panelists if I do attribute it to cost. But I don't know what the exact numbers are, but I do agree that there does appear to be a significant lean towards ad hoc arbitration as opposed to institutional arbitration in Nigeria. But there are many reasons for that, not just cost. Cost, of course, being one of them, in one form or the other. And that perception, as many co-panelists have pointed out, that it's more of a perception, but if you dig deeper, that might really not be the case. I think one major reason for that is, first of all, and those sort of trace the origin, if you like, to issues of commercial culture, as people from this part of the world, the history of how arbitration developed in Nigeria. But I would say the main thing is perhaps flexibility. Parties see ad hoc arbitration as giving them a bit more flexibility than an institutional framework would perhaps provide. So parties can select the arbitrator, they can fix the timeline, they can decide what rules will apply. Are you going to do documents alone, or would there be need for a hearing? Things like that. So that flexibility sort of dovetails with commercial culture of Nigerians, if you like, where people sort of like more customizable options as opposed to being, boxed into a sort of framework that an institution might give. Another sort of reason why that might be the case, if you then look at how arbitration developed in this country, it matured more with the advent of individual practitioners, I would say. So, it had respected individuals who were arbitrators, and people sort of gravitated towards them as opposed to starting out with the institutions, the institutes, which are a bit more, present now in the country. So I think that's another reason. And of course, the perception of cost about it in a cost-sensitive economy like Nigeria, that could also be one of the reasons. I would say that, and this is without saying one or the other is better, I think the optimal situation will be where parties do understand that they have the options of both ad hoc arbitration and institutional arbitration, and depending on the individual circumstances of the case, whichever one would be preferable, I think they do have that option. That's when you'd have a more developed sort of ecosystem where both are equally respected and understood that it can give you what you want. I would say we're sort of in a transitional phase now, where the ad hoc arbitrations are there. If you even look at it, you can argue that there is sort of a hybrid approach in some cases, which is you have an ad hoc model, but you then rely on the institutions for things like appointments, for example. If the parties are unable to agree on an arbitrator on a panel, you then perhaps lean on the institute to help you help the parties reach an appointment and set what rules will govern. So I think that's where we are. I would say it is not good that we continue to experience an over-reliance on ad hoc arbitration, because, of course, that the institutes do provide certain advantages. If Nigeria is looking to position itself as a regional hub or a destination of choice for arbitration, you then have institutes that, there are certain qualities they bring to bear. They provide training. You have a standing panel of neutrals. You have they essentially provide ethical rules and things like that. So I think you can't do away with the institutes, and if we must then graduate to the next level of our arbitration journey as a country, we must look at obviously more use of the institutions alongside, of course, ad hoc arbitration. Thank you.
All right, thank you so much, Mr. Akwaya. My next question would be to Mrs. Oshodi John, because I saw her expressions. on why parties, prefer ad hoc arbitration over institutional arbitration. And I know that the Nigerian Institute of Chartered Arbitrators does a phenomenal job when it comes to setting the tone for arbitration in Nigeria. And being an associate of the institution myself, I see the big role in which they play to really growing the Nigerian ADR economy. So my question would be to you is, what can you highlight to us the role that the institution is currently playing in the growth of the ADR economy in Nigeria?
Thank you very much, Jessica. Nigerian Institute of Arbitration, I can speak to say today, serves as the driving force for arbitration and ADR ecosystem in Nigeria. In the last 47 years of our existence, we have been able to train over 8,000 professionals as arbitrators. NICAB has moved on from being a national institute to becoming a regional institute. And so we have members from different countries in the African region as well as from overseas. NICAB is not just involved in training. That's why when you gave the question about ad hoc and institutional arbitration, I laughed because it's a question that I would love to talk about. But NICAB has an arbitration and ADR center that administers arbitration matters, both ad hoc and institutional. And we have, in the course of the last 10 years, seen more of ad hoc. I would say ad hoc, 75% of our matter disputes are ad hoc than institutional. And I believe the reason why we have that situation is because of the level of understanding, knowledge among the users of arbitration clauses in Nigeria. A lot of people do not understand the importance and the role of arbitration clause in a contract. And so a lot of the time we see a lot of pathological clauses that are difficult to enforce, difficult to use, because the drafters of those contracts probably had gone online, seen something they liked, and just copied and pasted without taking into consideration the issues, the needs of the parties, the contract type, the likely issues that may arise if there is a dispute. And so I think as a result of that, even when some of these clauses appears to be institutional, they end up being handled as ad hoc matters. For a clause to be institutional, there's certain phrases, certain words that you need to put in the arbitration clause. For instance, you will have to add that the arbitration clause is going to be administered under the rules of the Nigerian Institute of Arbitration Center 2021 rules. You have to put that clause there. So even if you give NICAB the authority to appoint the arbitrator, if you don't have that clause in there, it is an ad hoc arbitration, though we are the appointing authority. So that is what we find. A lot of the time, people don't understand that for an arbitration matter to be institutional, there's a particular phrase you need to add to that arbitration clause. But as we see arbitration evolving in Nigeria, we begin to see a lot of professionals that we have trained now having a better understanding of the difference between both clauses. And like Oke has said, if we really want to become a destination for arbitration, we need to move away from ad hoc to institutional. A lot of the arbitration matters face challenges when they're handled by an ad hoc model. Because for institutional, you know the rules, you know the institution, you know that the institution has expertise, the panel of neutrals are trained, are experienced, and the institute has the opportunity to look at the dispute and to determine who exactly has the right skills to handle, this dispute. And I want to say that one other thing that NICAB has done is that we have pioneered training for young arbitrators at the university level, even at the Nigerian Law School as well. I'm so happy and excited today to see the Honorable Director General of the Nigerian Law School sitting before us. This is something we have done over the years and we continue to do. And the reason why is because we want to make sure that we are not future ready, but we are ready, starting from the young professionals level to the most experienced level, to handle arbitration matters and disputes that come our way. Like Olamide said, we need to look at ADR not just only from arbitration, but also from mediation perspective. Because some disputes will be better served, will be better handled under mediation than arbitration. And so this is the things that, as legal practitioners, we have to sit down, look at the contracts we are drafting, make sure we understand the issues that may likely arise, the complexities that may come up as regards this contract, and put in the right clauses so that the parties at the end of the day are able to resolve their disputes in the right way. Thank you.
All right, thank you so much, Mrs. Oshodi John. You mentioned something so profound, how the way we draft the arbitration clause really matters a lot. It's not just about copying and pasting templates, draft clauses for the arbitration clause, but looking at certain considerations when it comes to the parties. Also, if they want to submit to institutional arbitration, certain things that must be included in the arbitration clause. So it's really a call to action for legal practitioners and lawyers to pay critical attention when drafting the arbitration clause of an agreement. So my next question would be to Prof really quickly on the fact that you have a wealth of experience with international arbitration as well. So how do you think Nigeria can position itself to be a preferred seat of arbitration in Africa when established hubs such as London, Paris, Singapore, Kigali are already dominating the market? What can be, how can you say Nigeria can set themselves apart in this regard, sir?
Well, once again, thank you, Madam Moderator, for that question. Permit me to reframe the question or to interrogate the question. While I am prepared to accept that London, Paris, Singapore, and Kigali have established a reputation out there, I'm not prepared to accept that they dominate the market. They don't dominate any market. What has simply happened is that those jurisdictions have upscaled their practices to embrace best international practices and conventions such that they inspire so much confidence amongst stakeholders around the world, and they become preferred jurisdictions to attend in order to resolve both international and domestic disputes. They don't dominate anything. And as a result, I say there's a lot of scope for Nigeria to also place itself in the same bracket with London, Paris, Singapore, Kigali, and other jurisdictions by simply embarking on steps that will ensure that they embrace best practices. And these steps are, should I say, quite a number, but they're not difficult to achieve. And part of what we're doing here is also part of what we need to do to ensure that Nigeria gets to that destination. Now, there is something known as the London Centenary Principles that was promulgated sometime in 2015. And what that set of principles does is it signposts a number of items or issues that any hub, any aspiring destination or jurisdiction should embark upon in order as to put itself out there in the same bracket with London, Paris, Singapore, and Kigali. First and foremost, I run through them. You have to have an enabling and cooperative judiciary. Apart from an enabling and cooperative judiciary, you also need to have an essential legal expertise. And apart from the legal expertise, you also need to have institutions that are prepared and well positioned to provide the right education to educate those who are aspiring to become arbitrators or dispute resolvers, because as we made clear from my co-panelists, it's not just arbitration alone. It also includes other forms of dispute resolution, including mediation, conciliation, expert determination, adjudication, and early neutral evaluation, and including negotiation. All of these are different aspects of alternative dispute resolution that complements the arbitration and ADR ecospace. So we need to have institutions, strong institutions that devote their time and resources to educate and to continue to educate those who are aspiring to embrace these mechanisms for resolving disputes. And I must commend what NICAP is doing, collaborating with the universities and the law school, and in fact traditional rulers, to continue to educate everyone to embrace arbitration and ADR. And whilst I accept that lawyers have to be in the forefront, let us also remember that this is not a lawyer's special preserve. We also have to invite and embrace other professionals like architects, surveyors, engineers, and accountants. But what tends to happen is, because we have a lot of big named lawyers dominating the space, other professionals seem intimidated and don't want to feel they cannot participate or collaborate with the lawyers. But what I say is the lawyers should provide a leading role, as this branch is doing now, and embrace other professionals and have joint sessions to talk about, sensitize, and create the necessary awareness about arbitration and ADR. So I've mentioned about 4 different matters which would enhance this jurisdiction. I've mentioned judiciary, the legal expertise, education, then you have ethics. Then of course there's accessibility. We have problems in our policy that we are not talking about that could discourage international participants or stakeholders to come to this jurisdiction. The bar, as well as other aspiring dispute resolvers, need to be in the forefront of ensuring that we criticize or sensitize those who govern us to ensure that this jurisdiction is made more secure and more stable, in order to ensure that those who are minded and who will be convinced to come to Nigeria to resolve disputes will feel safe to do so. But apart from stability and security, we also need to have also the necessary supporting institutions, whether it's hotels, hospitality, and those who support the arbitration process, all well positioned to ensure that this hub becomes a reality. One more thing I must mention before I hand back the microphone is also to ensure that arbitrators and arbitral institutions have immunity. Immunity from persecution, immunity for prosecution. This, if you like, practice of either intimidating arbitrators or intimidating arbitral institutions must stop. And I'm happy to mention that at least our judiciary have taken very bold steps in certain decisions that have come into the public domain to ensure that this becomes a thing of the past. So these about, I think I've mentioned about 8 of them, but if any of these 8 features are given considerable attention, then of course Nigeria will be very much in the forefront of becoming a hub. Look, I don't have to go very far. Even in West Africa alone, from Cameroon on our right to Togo, the French-speaking Africa, and also to English-speaking West Africa, be it Ghana, Sierra Leone, or the Gambia, there's a lot of scope for Nigeria to be the hub of the preferred jurisdiction to entertain arbitration, international arbitration and ADR processes. Mr. Oke mentioned AFTA in Ghana. That is also a process now that will ensure, if properly interrogated, if properly followed, will ensure that Nigeria, with the capacity that Nigeria has, and all these other things I've mentioned, these are steps that need to be taken to ensure that Nigeria becomes a hub and finds itself in the same class of hubs that were earlier mentioned, such as Singapore, Paris, London, even Hong Kong and Dubai. These are all jurisdictions that have elevated themselves. And as I said earlier on, they don't dominate anything. It's just that they've been able to upscale their practices such that it has become common knowledge within academics and commentators that these jurisdictions have a lot to offer in terms of best international practices. I think my time is short, let me stop there for now. Thank you.
All right, thank you so much, Prof. Our time is far spent. So before I ask my final question, we are a profession of order, and I would like to kindly seek a brief extension of time of 5 minutes from Gabriel before I proceed to ask the final question. 3 minutes. All right. Thank you so much, Gabriel. So the last question is to you, Ms. Adineye. We have spoken so extensively about arbitration, the expertise, and I know that Mr. Ekwaya has said in his keynote speech, one profound thing that can help to build the ADR economy is mentorship from older lawyers, considering that this is a close-knit field. So what would be your advice that you would give to young lawyers and professionals that are seeking to build successful careers in arbitration and ADR? And what is your charge to the older generation on how they can help in this respect, ma'am?
Okay, thank you very much. It's very interesting that myself and Prof chatted about this just before, coming up, and the general perception that is close-knit. And so my advice to the young and upcoming lawyers would be start early. Build a solid career in law and dispute resolution early. And I would say that don't give up. So some people have resigned themselves to fate, saying, well, I don't think I can ever penetrate. Arbitration belongs to, the privileged few, the elite lawyers. But the truth is, if you don't give up, you are proactive, you are intentional. So I think the word is to be deliberate and be intentional. Build yourself up, continue to learn. We talk a lot about continuous learning. It's very key. And then I was having a discussion with Prof as well, and so we keep learning every day. So today, while waiting for the conference, for this session to start, I engaged Prof, and I learned a whole lot from him, And so one of the things that he also said, about, attending conferences, going for trainings, apart from the knowledge that you would gain, you are putting yourself forward as well, before your mentors. And then when an opportunity arises tomorrow, then they remember, oh, that student that was in class. And I always say that when you attend a training session, a conference, it's always good to not just be present, but be purposefully present and be powerfully present. Ask questions, contribute, so that the facilitators, the mentors that are there would remember you when an opportunity comes. So I'll say start early. And I really want to also commend the Nigerian Institute of Chartered Arbitrator, Mrs. Oshodi is here, the chief on a lot of highly committed in trying to promote arbitration and ADR early colleges, also by offering them special discounts and to just encourage them in this line of my advice today. And then to the young lawyers, I want to really grow yourself in arbitration. Please, when you come to the arbitral table, remove the adversary. We know litigation is very adversarial. And then you see the young lawyers, approaching arbitration or ADR. I must win, they must lose. It's not a win-lose thing. So you have to be open-minded and have to be focused on resolving the disputes rather than having a win-lose situation. Thank you.
Thank you so much, Mr. Dele. This has been such an We're meant to have questions and answers, but we have to go on a break. And thank you so much to the wonderful audience for listening to this session. Ms. Jessica Obodeloe, and it has been such a pleasure to moderate the arbitration. The viability of ADR at building Nigeria's ADR economy. Thank you so much, distinguished panelists. Question?
Thank you very much. You can do better. You know, sometimes I like to think like a judge and say the witness, but today I'll be myself as the master of seek the permission of the panelists to that the panelists charged. Thank you very much. Please, we shall quickly do a picture before proceeding to the next session. Just 5 minutes. Mr. Chairman.
Colleagues, ladies and gentlemen, I will only be speaking to my paper, which is Training Lawyers for a New World, Legal Education, Profitability, and the Demands of Justice. And because I teach at the Nigerian Law School, I will only speak from that perspective. The Nigerian Law School Council of Legal Education having oversight over who comes to the Nigerian Law School. So we understand the history of legal education in Nigeria. I'm sorry if I'm adopting this approach because I'm conscious of the fact that time is fast spent and then we want to try and make up for lost time. So we understand the history of the Nigerian legal education and we understand the role the Oxford Committee played in establishing, that now led to the establishment of the Nigerian Law School. Now, at the Nigerian Law School, we run two programs. We have one that we call the BAPA. One BAPA is for law graduates outside, those who graduated in law from foreign universities. And we do a makeup program for them for about 3 months. And then they join the BAPA 2. BAPA 2 in essence is only for 9 months. About 6 months of lectures, 3 months of extension. And before we had a curriculum review, we had 5 papers: civil procedure, criminal procedure, legal drafting and conveyancing, company law, legal drafting and conveyancing, company law, then general paper. Those who graduated before 2008 will be familiar with this. And then we had the general paper made up of 4 courses: law office management, legal practitioners accounts, legal skills, and professional ethics. Now, it became necessary in 2008, 2009 to review our curriculum, and that was done. And following that, law school now, we formulated our vision statement and our mission statement. Our vision statement, number 1, to be a model institution that aims to attain the highest standards of legal education and vocational training in the world, train lawyers grounded in the ethics of the profession who can respond to current national and international legal challenges in a diverse society, and then maintain vocational training and capacity building. Our mission statements include to educate and train law graduates in vocational skills that will enable them function optimally as barristers and solicitors. Now, with this curriculum, we started emphasizing what we call, or what we all know as lawyering skills. Lawyering skills will include analytical, drafting, listening, even the nonverbal communication. So with this curriculum, we have heightened the emphasis of these skills. So we try to develop in our students what we call lawyering skills. Now, the way we teach at the law school now, we've moved from 1 hour per course to 1 day per course, and the lecturers, not one lecturer, we go in a team, and everybody has a role to play. And we would have sent the curriculum to the students at the beginning of the session. The outline for that course, for that topic, would have been sent maybe 48 hours before the class. We will give them the recommended list, and then questions like tutorials for those of us that we don't belong to the Gen Z. What we used to have then was tutorials towards the end of the session. Now, so what we do is we would have sent the questions to the students. We expect them to read in advance to answer the questions, so that when they're coming into class, they come in with about 40% knowledge or content. And then by the time we finish with the interactive teaching and, questioning, they probably should leave with about 70% content, and then they make up in their private revision. Now, in trying to teach our students, we also need to understand that as a profession or in legal education, we should understand that there are 4 things that we are contending with. Number 1, we are contending with technology. Before it was you learn the drafts, you repeat the drafts, but now if you put your thoughts in paper and feed it to Gemini or ChatGPT, it comes out with something very beautiful. And if you are not careful, you probably will stop reasoning, and it may just be a question of feeding, taking, and take out. So you have that challenge that we have to contend with. We also have the issue of economic gain to the young lawyer, so that even though we are teaching, I would say that we have a large number of students at the Nigerian Law School, but if we ask them, less than 50% really want to practice law. And I think part of the reason is because they do not think that the practice of law will meet their economic needs. And I think that's also because we haven't, when I say we now, I mean everybody involved in legal education, we haven't made them to realize the opportunities open to a law graduate or a young lawyer. And then maybe a disruption that I would want us to talk about is this issue of access to justice. I'm happy that the previous session talked about arbitration or alternative dispute resolution, because when you talk of access to justice, it's beyond what we do to our to our clients. I'm also looking at it from the point of view of the institutions that train our students to become lawyers, so that when you look at the justice of the system, where, for example, I mean, because this is law school now, where you have a university that is not accredited to teach law, offering law, you would need to ask if justice is being offered to the students. Because what happens is such students, assuming a university is not accredited at all, so you now graduate 50, 100 students. Those students wouldn't come to law school because we do not know them. We do not know that institution at the law school. And then when there's now the clamor that we've graduated 5-6 years and we are unable, law school has refused to admit us, it is not because law school has deliberately refused or is deliberately refusing. It's because the university that trained them failed to give them justice, because the university was just not accredited. So we are looking at justice from that point of view. And then we are also looking at the issue of globalization. Now, if we look at what we teach at the law school, it may seem, I don't agree that what we teach at the law school is irrelevant. And you know that the students have come in from the university. They've offered the core law subjects to help them understand. But when they come to the law school, we teach them how to apply the law. Now, what we need to also understand is that the training from the university to the law school should complement each other. Now, bar final results were released a few months ago. Call to bar is in a few weeks, and I can't wait to see what the new wigs will post online, because the impression they give online is they survived. I wouldn't call it a death sentence coming to the law school, but they consider it an ordeal. And I was speaking with some people, and I said sometimes it is painful that at the Nigerian law school, our students do not maximize the time and the wealth of resources available to them. And they see law school as very tough, and it disturbs their mental health. And why, when I try to engage with some of them, I mean, a number of them have argued that maybe law school should be increased to 2 years and the university should be reduced by a year, because their first year in the university, they do not see the relevance of the subjects that they are doing. But I would say that everything adds up. And at the law school, our training is meant to be complementary. One area where we will expect but I wouldn't say support, informal training. Yes, that's it. Informal training is while the students are on externship. Our students are on externship now, but we find out that our seniors, our colleagues in practice, maybe they see our students as distractions or that they disturb them. They do not engage our students, and they do not teach them informally. We expect that the essence of the externship program is that our senior colleagues will get those students to write the letter. Let them observe client interview. If it is possible, let them sign the commitment as to confidentiality, so that they know how the law office operates. And then it's like saying that they've gone to watch a film. I tell them that sometimes when you go and watch a film and I come back and you come back, I say, tell me what happened. Naturally, everybody will tell you what happened without bringing out any notes. And so what we expect is that during the externship, our students will be engaged in a way that the experience and practice leaves a lasting impression on them, so that when they get, maybe the first hurdle is to pass the bar final. So when they get into the exam, they can relate and say, oh, when I was on externship, it happened this way. So we don't want externship to be an extension of law school where the lawyers in practice will just put our students together and take them tutorials and say, let me prepare you for bar final exams. We are doing that. What we want you to do is to prepare them for life in practice. And so I want to trust that when our students come back in a few weeks' time, they will say, the way we were stretched, lectures at the law school was mild compared to the rigor that they saw or they experienced during the externship. So another way I think we can develop or improve on what we do at the Nigerian Law School is interaction and engagement from those in legal practice. I recall when we were at the law school, we had seasoned legal practitioners coming in to teach. The truth of the matter is the law school or even the universities cannot teach every emerging area of the law. I think what we should do or in assessing ourselves is to ask if we've been able to prepare individuals to be able to apply, to be, to thirst for knowledge and to be able to apply the knowledge that they know. So that if they attend a webinar, for example, or they are here attending a conference, or they have somebody speak to them on an issue of the law, they can investigate that area of the law and move on. A lot of us, when we were at the law school or university, there was nothing like AI, and a lot of people are doing it. In fact, I'm not too sure if we had aviation and arbitration. This was strange to us, but you have people thriving. So it is impossible to expect that we will teach every area of the law, but I think we will succeed. We can, in assessing how successful we are as lecturers or as those who are gatekeepers in training, I think what we should do is to determine whether our students are prepared and they are able to think. If you have students who are running away from questions and tasks and complex issues, probably we haven't created that inquisitiveness in them to be able to look out and to say, yes, this is an issue, let me read around it. They know where to go in terms of research skills and the like. So I think in talking about legal education and access to justice and how relevant is legal education to the practice of law now, I would say that if we can answer this question, that our students are willing to engage and to expand, then I would say that we are succeeding. And at the law school, we currently have what we call the Arise. Our target mainly is to ensure that we carry out the vision and the mission statements of the Nigerian Law School. In doing that, lecturers, of course, will stretch ourselves, will teach, will be where, I'll say that the Nigerian Law School, every staff of the Nigerian Law School is, if it's more than 100% committed to the institution. And I say this because irrespective of whatever it is that we go happening around us or within us, we still go to class. I recall once that a colleague of mine was involved in, let me say, an accident. She was coming to work. It rained heavily, and she fell down. And she still came to class. And I was wondering that what's the problem? When she told me her predicament, I told her, please, you can go. But she refused to go, and that tells you the extent of commitment of the lecturers and admin staff of the Nigerian Law School. So at the Nigerian Law School, we are committed to, to teach and to do our work. So we improve ourselves, but we have a limitation in terms of infrastructure that we have on ground. I admit that, because what we want to do, we're a bit limited in terms of having the business of law, for example, is not a topic we'll teach at the Nigerian Law School. It's something that our students should know, and I have colleagues who really want to teach us, but you can't go to one campus without going to the other campus, and we have 7 campuses across the nation. So we are trying to network all our campuses so that, reach topics like this, the business of law. My boss in those days would say the practice of law is a business, is a profession, it is not a hobby. And if you understand that it is a business, it is not a hobby, then you actually know how to price very well, and then maybe the economic issue would be addressed. And so we also look towards strategy or synergy between our stakeholders. And it is really important that our colleagues in practice would seriously engage with our students, while we also expect that at the university, we shouldn't have a student coming to the Nigerian law school who cannot hold the microphone, for example. I believe some of our students are here, and when you pass the microphone to them, it's as if you've given them a death sentence. They should have been prepared from the university. They have more courses, maybe more lecturers, so that everybody is prepared and they look forward to coming to the Nigerian law school. I hope the issue of highly itinerant lecturers at the university will also be a thing of the past. And so, in terms of, so I've mentioned the infrastructural issue at the Nigerian Law School. We've talked about sustainability and stakeholders' participation. And then we're also working on getting everybody involved in terms of digitization. So we are hopeful that we will get across to everybody our benchmark in terms of what we expect from law offices and law universities in the course of this, before the end of this year, because we want to form, the basis of that will be from an empirical study that we are going to conduct. We are already working on the survey to send out. And so, so while we say that legal education, I've tried to emphasize that legal education does not start and end in the classroom. We should understand that legal education goes beyond law faculties, it goes beyond the law school, and everybody is meant to be a mentor. When our students come to you, we expect you to enforce more or less, or to encourage them to get into the practice of the law. And then when they leave, as I tell the students, you don't have a second opportunity to make a first impression. But also as the law office, it will be good to leave a positive impression on them that, oh, when I did my law office attachment externship, I was with this law firm. I want to go into this area of the law because of the way Mr. This or Chief This handled the cases when we were there. And so education is not university, you've done your own, secondary school, you've done your own, law school, you've done your own, and so let us apportion blame. It is a process that should, a synergy between all these institutions, really. And so while we are trying to improve on ourselves, every other aspect of provider, and you see everybody is also trying to work on themselves to ensure that we have a solid legal education, and that when our students come to the law school, or when we see them in practice, we are sure that we are happy at our products. Another thing that we would have to look at is how we assess our students. Where, for example, you have external facilitators coming, for example, on the business of the law, it may not be an area of the law where we will set exams, so that our students won't be afraid of exam, but we should find a way of assessing them. And the almighty, the university exams is no longer almighty on a semester basis. And then the bar final exams together will complement them. There is no point having a law graduate that you ask a basic question as maybe types of interest someone can have in land, and they're looking very, very blank, and you wonder, sometimes jokingly in class, I ask them, which university did you finish from?
But it will be good if all these basic things are taken for granted. So how we assess our students at the Nigerian Law School, they are saying that the way we assess is difficult, but it's really not difficult, but holistically, that is also something that we should look into. And then ultimately, we will also need to look into how we, young lawyers, the economic aspects of the practice of law, are we practicing law in such a way that even with all the rigors, university, law school, whatever it is that they are being paid should be worth the while. And so we are also saying that this issue of pupillage should not be optional. They have to, maintain maybe that 1 year or 2 years so that they are taught, they are trained, they are groomed for practice. And of course, it's not going to be free of charge to our interns. And then I'll also say that while each university has the opportunity of developing 30% of its local content, it will be good that these areas of emerging areas of the law, it's something that they can, each university will develop. And then you'll find out that a student coming out from a particular university has been exposed to one area of the law, thriving in that environment. There's no point saying that you are in Lagos and you want to do one aspect of law that is not relevant or thriving in Lagos. So I think that if we do this, then I'm sure we would say that yes, our students are ready and that we have improved on legal education. Thank you very much.
Please keep clapping as she takes her seat. So we shall move quickly into the next session, which is a panel session for the Director General of the Nigerian Law School and the Deans of the Faculty of Law. So if you look around very clearly, you would see that every accomplished lawyer was once nervous of writing law exams. And every senior advocate of Nigeria was once learning how to draft statement of claim or statement of defense. Every judge was once studying for an exam, and the future of the profession depends on how well we prepare those who will inherit it. That brings us to the next session, and permit me to mention an African proverb that says, "The child who is not taught today will be a challenge for tomorrow." The same is true for the legal profession, but we have our professors, our teachers, the custodian of legal education in our midst to direct us, to teach us on how to be better lawyers. So I'll run quickly into calling the panelists. And the first on my list is the Director General of the Nigerian Law School, who just gave the keynote, Dr. Olugbemisola Odushote. Please keep clapping as she makes the stage. Then we have Professor Abiola Sani, Senior Advocate of Nigeria, the Dean, University of Lagos, ably represented by Professor Wale Olawoyin, the Head of Department, Commercial Law, University of Lagos. Keep clapping until he takes his seat. We also have Professor Karim Adebayo Olatoye, the Dean, Lagos State University. Keep clapping until he takes his seat. we have Professor Ekundayo Vera, the head of Department, Private and Commercial Law, Babcock University, and she's here to represent the Dean of Law, Babcock University, Professor Dorcas Odunaike. And finally on my list, we have Professor Bade Akinrimade, Dean, Olabisi Onabanjo University, Ago Iwoye. Please pardon my... She is represented by Dr. Olufumilola Olabode. Keep clapping as she makes a seat. Then to marshal this session, I'd call on the chairman of the Nigerian Bar Association, Eti-Osa branch, Mr. Olarewaju Obadino. Keep clapping. He is the host and is also the marshal of this session.
Ladies and gentlemen, I was actually not scheduled to be the one to anchor this session. When we prepared the program for the event, and my friend and close brother, in person of Olabisi Makanjuola, heard about this session and the fact that Dr. Olugbemisola Odushote will be coming from Abuja to be part of it, he offered to be the one to anchor this session. He actually changed his ticket to return back to Nigeria yesterday, but unfortunately the flight was delayed that he had to come in few minutes ago, like 30 minutes ago. He just landed and called me that there's no way he can make it to this place, but he's just leaving the airport. That is when the responsibility squarely fell upon my shoulder. And why am I afraid? I'm afraid because of the kind of responses I will be getting to the probing and thought-provoking questions I will be throwing to the teachers of law that mentored us while we were at the university and also at the law school. The fear of fit and proper is the beginning of the wisdom. Immediately Dr. Olugbemisola entered this hall this morning. That fear that enveloped me while I was at Nigerian Law School, Abuja, during the time of Tahir Mama, enveloped me. I started ensuring that every step I take is fit and proper so that I will not be sanctioned. I appreciate you, ma. Dr. Olugbemisola was actually the first person to come this morning, and that was why the fear becomes so palpable on me. She walked in as early as 9 o'clock and, humbly sat at the back waiting for us when the entire hall was empty. And as God will have it, she accepted my plea and she waited till this time. And I want to believe that everyone enjoyed the keynote address that she gave here today. It is well deserving. Please let's share Dr. Olugbemisola Odushote for that. Thank you, ma. God will continue to strengthen you, and under you, the Nigerian Law School will witness unprecedented innovation by God's grace. And that takes me to my dear brother, Professor Wale Olawoyin. This makes it the third time we are beckoning on him to come and share with us the erudition of his knowledge of law. And circumstances of life has not made it happen. Sometimes he will be out of the country. At another time, his schedule will just not be appropriate for it. So as God will have it, we were at the University of Lagos last week, and Professor Abiola Sani said, Lanre, I know what to do. Let me take you to your brother. He will be the one to anchor your session. Immediately they opened the door. I didn't even know that it was the one we are going to meet. I told him that he has no hiding place, that this time around he must be here. And that's how Professor Olawoyin SAN made it to this place today. So please appreciate him. He's been a great mentor. He has been so helpful in the journey of my life, and I cannot, take it for granted what I have learned through him and his other friend. May God continue to protect you for us, sir. And to Professor Olatoye, I feared him so much, even though I've never met him before. I will call like 10 times, he will not pick the call. And I will be so afraid because the MBA Eti-Osa has a lot of Lagos State University graduates, and they are doing exceedingly well. And may I let him know that the alternate chairman of the planning committee is a member of MBA Eti-Osa, and is also from law school. And he is from LASU. He finished from LASU in person of Tayo Ismail. We have the publicity secretary of the branch in person of Kim Abbas, who is also a graduate of Lagos State University, and many more. So all of them indicated that they want their dean to be part of this. So I will keep calling. Prof is quite busy. So until last week, after I left LAG, I just called him. He said, "You have been calling me. I've been seeing your messages. I will attend your event in person." And I was so glad that when I called Tayo this morning, he said, "Prof is already on his way." And as I stepped out of the hall, I was there seeing him alerting from his vehicle. So please celebrate Professor Olatoye. To the representative of Professor Gbade Akinrimade. Gbade Akinrimade taught me jurisprudence at Nigeria at Olabisi Onabanjo University, and is the one that brought me to Ajah, because when I left the law school and came to Lagos to work, I happened to work with him for the first time in Lagos. That was the first time I knew where Ajah is called on the map of Nigeria. He is my teacher in school, and he later became my employer. And that was how I became rooted. And today, it will have been a thing of joy if he's here to see that that boy he nurtured to Lagos is now the branch chairman of the same enclave where he's practicing his career as a lawyer. And I appreciate him. Please extend my greetings to him. And I also appreciate you for coming to represent Professor Gbade Akinrimade. Let's go to the business of the day. The topic for this session is training lawyers for a new world, legal education, profitability, and the demand of justice. My questions today, like I said earlier, will be proactive, and sometimes it will sound provocative, because I look forward to generating meaningful discourse on this subject matter. And the first question I will be asking today will be directed to Dr. Olugbemisola Odushote. Ma, ever since I've been into school environment, the most dreaded school I've ever been to is the Nigerian law school. I just don't know why. That even when you see things that should ordinarily provoke you, you will just decide to comport yourself because of that slogan, fit and proper. How adequately is legal education currently preparing graduates for the reality of a rapidly changing legal marketplace?
Okay, you said law school, students are afraid of law school, and that when they see things, they don't talk, and how are we preparing them for the marketplace?
Yes.
Okay, I think the reason why a lot of students that come to the law school are afraid of the law school is because, law school is one institution that we stand by what we say. If you, for example, and we don't spring surprises. It's not as if we come out to now bring out one joke at the end of the day. When the session resumes, we have 2 weeks orientation. We have a code of conduct that every student would have signed upon registration. So every law that we apply is not new to the students. The only thing is that sometimes I feel that sometimes students feel that when I stand there and I beg, they will just say, you can go, don't do that. Maybe that's not a way in the university, but sometimes if we've given you the first warning, maybe a second warning, then you will have to serve the time. Sometimes you can't be warned. The only way you can be warned is to be asked to leave, But I think that when we, at orientation, we teach our students, we ask them, why are you at the law school? Because we know that not all of them will, in fact, maybe less than 5% of them will want to be teachers, law lecturers, so, and we ask them this question. So, and then when we set our questions, when we interact with the students, there is life after law school. There is life after law school. So what we try to do is just to make sure that sit for the bar final exams once and make sure you pass and go out and face law school. But I think the problem is parents are reluctant students of the Nigerian law school. Some are just there because their parents have said they should come, and that after 1 year, give me your certificate, go and do whatever it is you want to do. So a lot of them, maybe retrospectively, if you ask them, they will say, oh, law school was not that bad. It was just that I was not prepared for the volume of work and then for the discipline that you need to pass the bar, to survive and then to pass. Because that is actually life. If you are in an election petition, they bring this volume of books and everything. You must read through. And that's part of the pressure in life. So I think we prepare them for the future with the curriculum, with the activities and everything. A student said they close at a particular time. They say have to go for group meeting and they say have to come to class. I said, welcome to adulthood. It's just you. You are not married, you don't have children, you don't have a mother-in-law, a father-in-law staying with you. And you have to do all those things to get ready for life. So I think we are preparing them for life.
Please, a round of applause for Dr. Olugemisola. To buttress this assertion, while I was in law school, those people that are working as security guard that will be in front of law school, that will be assessing you to be sure that you are wearing white black trouser and that you are not wearing one canvas that has red color. When they see you dressing appropriately, they will tell you to go back to the hostel to dress, and you will not argue with them, you won't fight them, you will go back. Those people that work in Abuja Law School that time, doctor, they are cognizant of that fact that there is a regulatory power over us that will not make us to flex what we really have, who we are. I could imagine going to the back of the boys' hostel at Block F, that was where I was that time, and you will see these boys fetching water for those creme de la creme children, and they will be struggling with those who could not afford to pay them to bring water to their own room. They will queue up, they will be throwing their bucket away, and I will look at them, they will not fight them just because of fit and proper. That orientation really, really humbled us. And I think it is what makes the profession quite unique. You see chartered accountant, you see current certificate engineers that still come back to law school to come and study to become a lawyer. I've seen permanent secretaries of ministries coming back to study law and still come to law school. But I doubt it if I've seen any lawyer that was called to bar and decided to go back and study any of this profession. Lawyer is unique. We are the best profession on earth. Please celebrate yourself, lawyers. My question is to Professor Wale Olawoyin. What skills are today's employers and clients demanding that law school are not sufficiently teaching? What skills are today's employer and client demanding that law school are not sufficiently teaching? I think what are the new innovations, what are the new skills that is inherent in this practice that the teachers, both at the university or at the law school, have not had their mind to?
Thank you very much, Chairman. Let me again thank you for your introductory words and the fact that I've not been able to attend any of the conferences and the way that Professor Sonny twisted me into attending today, because I had to cancel a trial and to take an adjournment because I couldn't face Larry again by saying no. And sitting down, even listening in on the arbitration session, I was so excited. I thought that was going to be question and answer so that I can also engage on some of the issues that my good friend High Chief and the other panelists talked about. So what are those things that law school doesn't teach lawyers that employers essentially require at this point in time? And it's an extremely interesting question in terms of these current discussions around the fact that our graduates are not fit and proper for the legal ecosystem, for the marketplace. A lot of blame is put on us in the university, but I must say that quite a lot is directed at my very good childhood friend, the director of the Nigerian Law School. And when you really look at the current ecosystem, and you are making a point about charge and bill lawyers, the first thing I would say is that when we're analyzing the legal ecosystem, we should not just be looking at the commercial lawyers. I mean, they're the ones that complain the most, the big law firms or the medium-sized law firms. They are the ones that complain to us that, oh, what kind of students are you churning out of the university to go to law school? Because when they get to us, it takes us 3-4 years to retrain them to be fit and proper lawyers. We know that in the university, our job is just to introduce them to the law, to the first principles of the law. And that has always been the style of pedagogy in the university. Now, some people say that we really need to change that in terms of equipping our students to be fit and proper. So try to change the style of teaching and then also change the curriculum. Most universities in Nigeria today are going through that process of changing the curriculum. We're doing that in Unilag. And what is important in that endeavor is that we recognize the marketplace. And we then say to ourselves, what does the market need from us? Beyond just teaching sale of goods, teaching company law, teaching constitutional law. There are ways that you can structure your subjects now that you will still be teaching sale of goods. So a very simple example with sale of goods, which is an area that I teach. I mean, when you look at the jurisprudential underpinnings of sale of goods, it's essentially about consumer protection. Okay? So if you now develop a course that speaks more to consumer protection and regulation of consumer protection, and you're talking about competition and antitrust, then sale of goods fits in easily there. And then the students can get a better sense than when I go in now and I just start talking about the sections of the Sale of Goods Act all the way through, and then that's the end of it. Okay, so these are the things that we are also looking at in the universities, such that we're trying to take away the pressure from law school in terms of people questioning what really are they also learning in law school. So we're trying our best to as well to make them fit and proper. The marketplace has now come to realize that, for example, AI has come to stay. So this is another area that we're looking at in the university in terms of whether or not we have to put in place the policies, as a teacher of final year student, sometimes you just sit down, you read a project and you're saying to yourself, these students clearly did not do this themselves. So where do we draw the line? We know that when they get into practice, they will now have to probably be using AI. And the question would then be, what is the ethical use of AI? Because personally, I was a bit of a dinosaur with the AI thing. My resistance was not so much coming to terms with the fact that it's an aid that you could use well in your work. I was more fearful of the fact that at some point in time, would AI make all of us redundant? And genuinely, I had that fear.
Yeah.
I'm only coming round now. I'm not so sure that I've come round, you know. So these are the sort of things that we are trying to do in terms of equipping our students or our graduates for the marketplace, is changing the curriculum, making it more contemporary in terms of, and less doctrinal in our approach to also teaching. And that is why sometimes, you know, for a while in Nigeria, and DG mentioned it briefly about unavailable lecturers. I've come to realize that academics, and these are practicing lawyers and academics, help our students much better than just the raw lecturer. And this is also born out of personal experience. When I was doing my postgraduate in England, I was doing a subject that was being taught by an Oxford professor, solid professor. But there was also a part of the subject that was taught by a barrister, a Queen's Counsel. And the way and manner in which the Queen's Counsel taught the subjects was clearly different, because he comes into class with all the facts, the practical experiences and everything. So the way he taught the course was different from the Oxford professor, you know, and it was better for the students, you know. So that's just by the side. But so that would be my initial intervention.
Let's appreciate Prof. Let's appreciate Prof. Please, when you are clapping, let's clap well. Or else I will tell you that the number of clap will be the number of years that you will live. You know, we'll continue to clap till infinity. You see, I'm always weary of assigning talking responsibility to three individuals: the pastor, the teacher, and the lawyer. Professor Wale Olawon is a pastor, he's a professor of law, he's also a lawyer. So I wouldn't be surprised with the kind of response we got, and I think he really dealt with that question. May God continue to enrich your knowledge. To Professor Ekundayo, I want you to please address us on this. How can law faculty better bridge the gap between classroom learning and the legal practice?
Thank you very much. I'll just answer the question from our practice at Babcock University.
Okay.
Our students go for internship, you know, regularly, right from 200 level. They start going for internship, summer period, because we have a summer period of almost 3 months. And as faculty members, we also help them in assessing law firms that they can intern in. And we regularly receive reports from places like that. So we do that to ensure that what they've learned in class, they're able to see it in practice. They go to court. Some of them come up to say, oh, we don't know where to go to exactly. We help them. We link them up with practicing lawyers, even from old students that graduated from the school and all that. So we do that a lot, and that helps to give them a clear picture of what practice is really like. Another thing we do at Babcock is that we introduce our students early to professional organizations and institutions. Right from 200 level, they start engaging with relevant professional institutions. Places like, let's say like ICSAN, Institute of Chartered Secretaries and Administrators. So we give them a picture of law is not just about us going to court. There are so many other things you can do. They also engage in arbitration. Apart from teaching it as a course, they also take professional exams in arbitration, even in banking. They also engage in carrying out we engage them in several things. just to ensure that they have this perspective that law is not just about court alone. So we have a lot of clubs also within the school. We have clubs like Space Club, where we have clubs that have to do with media, clubs that have to do with law and technology. We engage them in several of these things so that they can have hands-on experience on what practice is. Because we observe that some of these students come in without really having interest in law. They don't want to study law. I have students that are now practicing law, not in the regular traditional way. You know, you find them like someone like Fosa, Faweimi Oyinkan, that is into media and all that. She was a student there, and while she was in school, she loved music. So we have students like that. So because of that, we have these students that are not interested in coming to class. They want to go and play music somewhere. They want to do this somewhere. So we try to make them understand that law practice is not about just going to court. So we introduce them to different aspects of law, or we link the law with different interests that they have in order to ensure that they don't lose their interest in law itself. So that's how we handle it. So law and practice. So we prepare them. So before they graduate from school, some of them are members of these professional bodies. Some of them they already have an idea of the aspect of law they want to engage in. They already have an idea of who is practicing this aspect of law that they are interested in, that can mentor them. So that's what we do in Babcock. Thank you.
Please appreciate Professor Ekundayo. I appreciate your contribution. And of course, while I was in the law school, I actually noticed that some of the people that came from private university, though that time Babcock has not yet commenced their law, I think they were doing international law at that time. I know you are the first. Did you start with law? Yeah, that's what I'm saying. So I noticed that some of them that came from some other private university, they've handled some courses like professional ethics in their faculty. They know more about civil procedure and stuff like that, which is quite alien to those of us from Olabisi and Onabanjo, and even the University of Lagos at that time. They too, doing the normal courses that are within the curriculum of the law faculties. So, and I want to believe that the effect of that training on your students will go a long way to prepare them for the modern day lawyering, and that will enhance us the ability to advance the course of the profession beyond our imagination. The next questions will go to Professor Olatoye. Prof, should courses on legal technology, business development, and innovation be made compulsory in law faculties?
Thank you very much, Mr. Moderator. My brother professor, my director general, law school, and my sister professor, and my sister here. Ladies and gentlemen, let me first apologize. You said, you put me on the spot. You had called me several times, and you will have to forgive us. You know, lecturing, the job of lecturer, let me say the business of lecturing, is, I would say, is it's a divine call, because if you are not fit for the job, you wouldn't actually be fit when you get in there. As a dean, ordinarily I should leave all the courses I've been teaching, but that's not how we're brought up. So as I do the administrative job, I still teach.
Wow.
So, and in the midst of that, the Director General of Law School would testify to that. I met her about 2 times. She was invited to one of the programs, curriculum development by, I think, ICPC, and then for MBA. So I met her there. So I've been to Abuja several times, for programs like that. And when I'm at a meeting, administrative meetings in the university, I'm in classrooms. If you called, certainly your calls will ring out. So I'm sorry about that.
Thank you.
But what's important that is that we're here today.
Sure.
Your question, whether technology should be made compulsory. Well, I will also answer that from the perspective of what is obtainable at Lagos State University and why we had to do that. Today you are talking about the topic of our discourse today is about
Training lawyers for a new world.
For a new world.
Legal education.
Yes.
Profitability
So
and the demand of
the
jobs.
new world is a global world. And when you are talking about training of lawyers for the new world, you talk about technologies. You talk about changing expectations of clients. And for you to be able to be competitive in the global stage, for you to be able to meet the changing needs of clients, certainly technology cannot be left out. And so it's important. I think when we talk about reimagining legal education, which will bring about reforms that a number of people have been doing now, the law school is working on something to hand them to the faculties. The NUC is also doing the same. And then, like the Director General mentioned, the NUC just came up with what is called CCMAS, and that CCMAS is the core curriculum that was handed that to the university. But we are given about 30% within which we can, decide what we feel will fit in for our students. And so, for our students to be able to cope, and being that we are in Lagos, we believe that Lagos is projected to become a smart city in the near future. They're working on that. To be able to meet the expectations in Lagos, you need a bit of technology. So in our own case, we have already made information technology law a compulsory course within that 30%. I don't know whether other faculties will be able to do that, but for Lagos, we believe that is very important. I've had a number of my students in the past who graduated doing that technology, and they have perfected their skill on that, and they came up to tell us that your chambers, having realized that they could work with technological tools, were asked to work from home. Sometimes you see them in the faculties, they come to the library to work, and now you are not going to work today. No, I've been given my assignment, and I just do it and send to my office. So we feel it's important. Every faculty that's capable of doing that should do. That's the tool that will enable them to play on the global stage. AI is the in thing now. Though in our own training, what we ensure, like the use of ChatGPT, for instance, we fondly call it ChatGPT. GBT, you know GBT in Yoruba? Because when a student uses AI tool to bring project and all that, by the time you go through and you find that there's little or no error, how could a student just coming up there, we're trying to guide, is able to do it perfectly like this? So what we do is to ensure that whatever they bring to us, they practically defend. So that's a means of, and this ChatGPT, though it's very useful, AI tool generally, but you find out that it could also put a lawyer into trouble. And it's part of our training that we let our students know that ChatGPT or any other AI tool could actually manufacture cases. And that has put some lawyers into trouble. You use it for analytics, and your analysis, in the course of doing that, you put cases that AI tool has provided. So when it gets to go and the judge realizes, they have to confirm. When they realize that you have used a manufactured case, it's a case for disciplinary action. So telling lawyers of today that you are not properly trained in this, So there is a tendency for you to just jump in there. For the students who are training, we let them realize all of that. But for you to just jump in there and bring out something that you feel is the genuine thing, you may be in trouble. And in fact, those AI tools are also honest to tell you that you should confirm whatever they throw up for you, because they could be wrong. So you can imagine it had also already put there, what do you call that? A clause that exempts it from liability in case you fall into trouble. So the caveat is there, but many people are not patient to check that, or that they just put in, get it, and make use of. We have to, but my preliminary comment will be that it is good if we can make it compulsory, but it's not all faculties that will be able to achieve that. It could also be made an elective course. We initially made it elective course here in Lagos, but later we deemed it fit to make it compulsory, and it's working for us. Thank you very much.
Please celebrate, Prof. Thank you, sir. You see, the comment I make at the beginning was not actually to throw Prof under the bus. It's just to appreciate him that even in his silence, he was committed to attend this event. In the scripture, as in the Bible parlance, there was a proverbial statement where they said a father told his child that go to farm, go and work, and he said, okay, sir, and he left, like as if he has gone to the farm, but he never did. But he called another one, he said, go to farm. He said, I'm not going. But after leaving the presence of his father, he thought within himself that, how can my father send me to go to farm and I will not go? And he decided to go. And the Bible recorded it that it's more profitable unto that particular child that honored his father and do what he said he's not going to do than for the one that pretended like he's going to. Quite a lot of people told us that they are going to come and they are not here today. Please celebrate every one of them that came. I appreciate you so much, sir. I appreciate you, man. May God continue to prosper you. To Dr. Olabode, how can legal education prepare lawyers to be financially successful without compromising professional ethics?
Thank you very much for that question. How can legal education prepare lawyers to be financially responsible? Now, one thing that we try to do as teachers of law, is we let our students know that, yes, we know that. Now, the moment you think money is everything, that's the foundation. The moment you think money is everything, then that means you're open to all sorts. That means we're trying to prevent where our students will go out there and then money will be the main thing that they think about. Then some of them may now become what we call corrupt lawyers. So some of my students, they know when I say, look, I don't, after all this, yes, I also teach law of contract and I teach commercial law. And I say, all this I'm saying, I don't want you to be the ones that will now go and then be all about the money. Don't be a corrupt lawyer. My students always laugh at me when I say that. Now, at the same time, we always tell them to find a balance. Because as a law firm, if there is no money, there is no way you can manage your law firm. At least you are going to employ, unless you want to be the sole lawyer in your law firm. Even if at least you must have a secretary or something. So the lawyer should be able to find a balance between, yes, while trying to observe the ethics of the profession, also get some financial knowledge on how to manage your law firm, such that you're not corrupt, but at the same time you're financially capable to own a law firm. We just tell them to just strike a balance.
Thank you, Doc. Please celebrate, Doctor. I allowed the first round to be expressive. They are teachers of law, and we cannot cage them in between the moderation, and that's why I will quickly reiterate at this point that for this next round of questions, we have just 2 minutes each to adumbrate on it. And the first thing I will ask is going back to DG, because I cannot have enough of her. She's quite erudite, and anytime the opportunity comes, I learn new things from her. Ma, if you have the opportunity to redesign legal education from scratch, what would you do differently?
If I have the opportunity to, I will answer your question, but two questions have come up, and I'll say that we can't answer these questions independent of our society. So in talking about law and money, and then the question, I can't remember the question for Wale now, but I mean, the society, not everything can be taught in the four walls of a school university. When we were in Ife, we had 3 square meals. You go to cafeteria with your tray and you will eat with a fork and knife. Now students don't eat with fork and knife. And that's part of the training of being a lawyer. We had law dinner. The students didn't eat. They waited for the benchers to leave before they now started using TikTok and recording, and they were eating anyhow. You know, it's a societal thing. But if I'm to have my, I need to be very careful. Number one, we need to be, there is a debate whether law should be a first degree or not first degree. I'm not too sure. But you see, we need to go back to primary, secondary, university. To be sure that every teacher actually wants to be a teacher, not a reluctant teacher. There's a difference between somebody teaching with passion and somebody saying, let me do 8 to 9, 8 to 1:30, and then I will go and look for a work somewhere. We need to get the commitment of the teachers. And we were talking about finances. Teachers go to the same market. Their children too will go to the same school. So you need to reward them. It was in time past that said teachers' reward is in heaven. They need to pay house rent. They need to pay school fees. They need to look well. So it's a reform, everything is holistic. So that when a teacher is engaged in school, in teaching the students, of course the students will come out. When we're in secondary schools, our seniors were training us. They were role models. Now seniors cannot even correct a junior. It is equal to bully. So there's a lot of reform that we need to do. If we get everything, even from the home, if we get everything right from the home, from primary school, secondary school, we'll end up producing better law. Is the entire educational system, not only law.
Thank you. Let's please a round of applause for Prof. That's well couched. And I want to ask Professor Olawoyin. We had a little, can I call it altercation or disagreement? I was asking Professor Olawoyin, based on my knowledge from the diaspora, on how things were being done when it comes to what we call Shajambe in Nigeria. I was telling Prof that in Canada, you don't see lawyer go to court premises and be running after overnight cases like the way we have it here in Nigeria. Before they bring any matter to court, it will have been documented, sent to legal aid, and the legal aid will be the one to distribute them among lawyers. Different law firms will just receive files and they will go to court to treat it. You don't see any police vehicle bringing inmates or overnight cases to court, and you see lawyer clustering around the vehicle. So and Prof was thinking that I want them to eradicate charge and bail as a practice, but that is not the. So what can we do differently to sanitize the era of sharp practices in legal profession and all this charge and bail regime in our court system?
Thank you, Larry. Your question is quite loaded because talking about elimination of sharp practices cuts across the entire legal profession. So it's not just limited to charge and bail lawyers. How we do that, I really don't know. It is something that we see. We see all the things going wrong in the profession, but we all just joke about it and we move on. because nobody wants to bail the cat. And the truth of the matter is that the attitude is that if you try to do that, you'll be thrown under the bus and you will be the one that would carry the can. But coming back to the charge and bail point, the point I was essentially making is that in the legal profession, there is a place for all of us in different aspects of the legal profession. That's the bottom line. If you set out your stall from the start that you want to be a commercial lawyer or an advocate in commercial law with the possibility of getting to the highest rank in the profession, all well and good. A charge and bail lawyer, without saying it in a derogatory manner, sees that this is my market, I'm comfortable here, and he earns his living there. You say it's that maybe they go around shopping for accused persons and clients, but we also know that in the US in particular, the so-called tort lawyers, who are very, very rich lawyers because of their contingency fee, they call them ambulance chasers. You know, so it's not really different when you look at it from that perspective. The bottom line is just that we all have where we can play comfortably. As I wouldn't be comfortable playing in the criminal bar, somebody else will not be comfortable playing in the commercial law bar or the charge and bail ecosystem. So that's just the point I was just trying to make, is that all of us in this room, we just have our different areas of strength where we're comfortable playing. Some weeks ago, I was at the SLP conference where the primary focus of the conference was on the opportunities in public international law. We all look at public international law from the doctrinal aspect, that it's a bit dry. You know, for those of you that went to Unilag, you will say, Professor Yebode, you know, solid, he teaches you all those principles, but you don't see yourself practicing in that field. But when we had Dr. Femi Elias, Dr. Adeogun Phillips now talk about the different opportunities, both in international criminal law, and then public international law generally, like law of the sea and those opportunities. It was an eye-opener. And they've just settled in that area. They've left commercial law, they've left all the other things for you. They've carved out a niche for themselves in that area, and they're doing okay. So it's just a question of where you decide to carve out a niche for yourself and you stick with it.
A round of applause for Prof. To Professor Olatoye. Are our law faculty producing lawyers capable of serving both local and international clients?
Thank you very much. Let me start on the note of addressing Eti-Osa Bar. I thank the organizers because I didn't have opportunity of doing that, because I had to defend myself on the allegation. So thank you for the opportunity you're giving us, because it may be the last opportunity, I don't know. We're going to have another round of questions. And then the organizing committee and all members. But I would say that given the kind of curriculum we operated in the past, and my interaction with Eti-Osa people, hardly would any of them claim to be thriving law firms without getting involved in real estate practice. Yes, any of my former students, no matter how attractive the area is chosen, like Ismail, who has chosen the area of technology law, by the time he states some of the other things he does is real estate. Yes, and they're into real estate. All of them. But the question we should ask is, are they able to play on the global stage? No is the answer. Because I've not had any of them told me that he brokered any transaction, real estate transaction, on the global stage. Buying for multinationals here, well, that one is easier, but buying for a client over there and preparing documentation, that needs an international or global touch. So they've not been able to do that. But the reforms that are being carried out in law faculties today, I think we'll be able to achieve that because they are now better informed. Like I said, areas of law that has to do with international market space, like cybersecurity law, information technology law. We have them introduce Faculty of Law, Lagos State University now. Now we have what is called ENT 1000. Though we teach it at 400 level, that's legal entrepreneurship. So we teach our students now to know that the art of legal practice is a business. And they start doing that, you'll be surprised. Some of the reforms that the law school is talking about, we already started doing that in our faculty because our moot court competitions, very active, clinical legal education, thank God the NUC has also introduced that into our mass now. So we have that. And so our students are able to consult primarily for their own constituency when they have disputes in their associations, elections, and all that. It's our students who undo that. And they earn their money for that through the teaching of the legal entrepreneurship. So aside from that, we teach them to be able to play on the global stage. So, and I believe that they are going to be more proactive when it comes to playing on the global stage. But for the crop that we have now, I'm not sure, maybe if I have a report of how many such international transactions have been engaged in by the Eti-Osa bar, then I'll be able to say what is obtainable now. But for now, I doubt. But in the future, given the reforms that are going on, I think they will be able to do that. Thank you.
Thank you, Prof. Please celebrate, Prof. But I can answer with all embodiment that even Tayo Ismail has been earning in dollars. Probably has not been telling you.
He has never given me any royalty to indicate that he's into international practice like that. So I'm expecting you,
Thank you, sir. So, Professor Ekundayoma, how should law faculty measure success? Academic excellence, employability, profitability, or societal impact?
All of the above. That's just the truth because now you have to be deliberate, when teaching your student that they have to be result-oriented. They have to be fit for purpose. They should be employable. You don't want to get your graduates into a law firm and then they complain that they can't draft a simple letter. Things like that. I had an experience last week where a friend's daughter said she was looking for a job. And I linked her up with a law firm and she got there. And the first thing she said during the interview is that, I don't want to go to court. That's the first thing she said. And when I got the feedback, the first thing I asked her, I sent you to a law firm that is into active practice. And the first thing you are telling them is that you don't want to go to court. Why did you go for the interview in the first place? So what I'm trying to say is that we need to, everything, all of the above, profitability, employability, train them, fit for purpose. They have to be result-oriented. They have to know what they want. Because gone are those days where you tell students that once you finish, just go to a law firm. So from school now, you begin to see some of them that say, oh, I want to go into music. And then you tell them, how do you marry music with law? That's why you have courses like law and technology now. You now have things like corporate governance. You now have things to do with space law. You now have medical law. You now have law in different fields. You have to make them see that you can actually still practice this law, make money out of it, and law will give you an edge in any other field that you decide to specialize in. I think that's where the world is going to globally. So it's not straight-jacketed. It's not about being in one silo and say, this is law, so the only thing I can do is go into a law firm. So I think that's...
Please celebrate Professor Kundayo. That question is well answered. Thank you, ma. To Dr. Olabode, that will be the last question for this session. Before we ask, we open to the audience if they have anything they want to throw to any of our discussants. What emerging areas of law should every law faculty be teaching today? Emerging area of laws that law faculty should be teaching today.
Well, I can speak from Olabisi Onabanjo University.
Okay.
Like, the experience that we have right now, our 300 level students are taking law, ICT, and the law. So through that, we teach them AI and the law, data protection, and things like that. So I'm sure most of the law faculties also take this. Now, when we talk, I remember when I started practicing, and then they used to talk about, okay, can you be a compliance officer, regulatory or risk, risk compliance and things like that. Of course, then at first it was new to me until now we needed to now have to go for trainings and things like that. So I guess law faculties to at least some foundation into these areas too could be useful.
Thank you.
Thank you.
Please celebrate Dr. Olabode. Just like Professor Kundayo rightly observed and Dr. Olabode, quite a lot of new areas of law are springing up. We have someone that came to our branch some time ago to do keynote and knowledge sharing session with us on fashion law. We've had quite a lot of people that have come up with a lot of other innovations that has enriched our knowledge as a lawyer. And I want to believe that sitting here today to listen to all this reservoir of knowledge has enriched our faculty in no mean way. And it is like homecoming, bringing the Director General of the Nigerian Law School, who had prepared and produced us as a lawyer into the field, to be here today and see her, to come and share her experience with us. And you heard what she said. If the opportunity is thrown at her, what she would love to change in the curriculum of the Nigerian Law School. And you've heard from Professor Olawoyin, even trying to create a balance between the international practice system when it comes to criminal justice and like he has observed, what they consider as sharp practices here in Nigeria. By not allowing us to make advertisements, there's a way you cannot do your signage in front of your office that will, tag you against professional misconduct. In overseas, Canada, America, some quite Western world, you will see them do billboard, like those politicians, big board, with their phone number. Is your right infringed upon? Call so number. And nobody is asking them to come and face disciplinary committee for advertisement, which they forbid us from doing from law school. But so I believe we've learned quite a lot today, and we don't want to bore us with this session. Is there anyone that would like to ask one or two? I can just take only 2 questions from the audience. Maybe if there's anyone that has any question.
Distinguished panelists, my name is Chidima Obi. Thank you for that very erudite presentation. I wish the law students here will ask questions. I mean, they've been very quiet, but let me ask for them. The issue of the development into electronic law is very prevalent now. And my question is, and I'm happy that Professor Oloye, I hope I got your name right, Olatoye mentioned it, is that if you don't know the law, if you don't know the substance, and that's, I mean that's for our law students audience too, ChatGPT will lead you into trouble. And so, in as much as we are gliding into the new age of, telecommunication vibrancy, please, how would you drum this into the minds of our, I don't want to call them lazy youths, because we all have them at home, to know that, it needs to come at the tertiary training in the university and at the law school. How do you get them to know that you can't misplace reading, burning the candle with what technology can do?
Thank you, ma'am.
Thank you very much, madam. And that speaks to, the fears that Lagos State University had before we started allowing students to make use of it. The primary thing that LASU had to do was to have an AI tool policy, use of AI policy. So we had to set the boundaries, the limits, and how students making use of such tools could now be examined. So it's not just about giving them assignment to submit and you grade that now. They have to own whatever is in there. And if a lecturer reads it and ChatGPT or any other AI tool had vomited lies, and the students comes to repeat that lies, everybody knows that you are lying together with your tool. So students want to avoid that, and a lot of the times whatever they generate, they still go and confirm and all that. So if we have that orientation as being part of the course that you are taking, I think students will imbibe the culture of use of AI tool in a way that will not put them into trouble. They know the boundaries, they know the policy of the university, and they have to act within that limit. Thank you.
Please celebrate Professor Olatoye. I know our time is fast spent, and that's why we not want to entertain too much questions again. And, Prof. Okay. I can't say no to Prof. It's working. It's working, sir.
Okay. We wouldn't have done our duty. We have our panel. We didn't entertain questions from the attendees. And I'm sure I overheard distinguished Professor Lawan say he did have a number of questions for the panel. Okay. I think we should do justice to that presentation and that panel before proceedings are rounded up. And I'm happy that the...
Okay.
So, and both of us are quite happy to entertain any questions if there are any to be asked, and to give closure and completion to the entire exercise. I'm sorry I've interrupted your...
No problem, Prof. Thank you. That intervention is well noted. And I want to say this. Peculiar problem requires peculiar solution. This program is supposed to start on the dot of 10 a.m. Dr. Odushote came as early as 9 o'clock, like I said earlier, and she was sitting there at the back waiting for us to converge. The reason why we are delayed till this time was because most of us did not arrive in good time. It could be as a result of the traffic situation in Lagos and other issues that precluded us from coming. And that's why we are going to be having tea break after this session. Tea break that we're supposed to take at 11 o'clock or 12 o'clock, we'll be taking it at 3 p.m. It is a peculiar problem that requires a peculiar solution. We are going to do everything as it should be. While I was about rounding up this session, Professor Latoye beckoned to me that irrespective of how long we have stayed, every panelist here deserves to have a closing remark. True or false? Can I have a yes to that? Yes. So, because we are going back to their session to allow Professor Lawoyin to ask that provocative question that will require a provocative answer after the tea break, then we will be able to do that. So, may I start from Professor Ekundayo, your closing remark?
Thank you very much, sir. I'll just quickly say that, just to also answer the question of the madam there, schools now have policy, at least I know of Bapop.
It's 1 minute, ma'am.
Okay. Policies on the use of AI, because we're talking of technology. So I think deliberately, intentionally, school must have policies. AI is here to stay, but we must have policies around it. What percentage similarity is acceptable in your school is very important.
Thank you, ma'am. To Dr. Olugbemisola Odushote.
Okay, well, I'd like to speak to aspirants to the bar, the young lawyers in particular, that leaving law school or graduating from the university does not mean the end of learning. It's not possible to teach every law, and then I think we need to be inquisitive and develop ourselves. Yorubas will say, after being taught, you should go and teach yourself, and that's what I will leave with you, that you need to keep improving on yourselves. Thank you.
Thank you, ma'am. Please celebrate Professor Ekundayo and Dr. Odushote for that remark.
So, in making my own closing remarks, I will speak quickly to two issues that Dr. Odushote sort of mentioned in her keynote address. The first one is that she says the curriculum in the universities should complement that of the law school. And I agree 110% with that. And I think the universities are doing that. I'm excited by some of the things that I've heard from Professor Latoye, which I'm going to steal to Unilag and tell Professor Sonny about. And then the last point is about, she says that good education goes beyond the university and the law school. And I say that good education, we should look before universities and the law school. In fact, I think we should now be looking more at the secondary schools. They are no longer the secondary schools of when we were in secondary school. I mark scripts of year 3 and year 5 and postgraduate. And if you're aspiring to become a lawyer and your grammar is poor, then really you're already playing on the back foot in the profession. So that would be my own advice too, is that we should not blame the universities and law school too much. We should also look at the foundation from secondary schools at least. I don't want to go as far back as primary school. Thank you very much.
Thank you, Prof. Please celebrate Prof. Let's clap, please. Celebrate Prof. To Dr. Labode.
Thank you. I'm just going to talk about, I'm going to speak to the theme of today's sitting. Just that our main goal in the Nigerian legal education is just for our students to know that, when we talk about profitability and justice, they are not really, it's not like they are different from, it's not like they are contrary to each other. They can actually complement each other. So we want our students to always find a balance between profitability and justice.
Please celebrate Dr. Labode. And to my erudite professor of law, Professor Latoye.
Thank you very much. I want to say that the younger lecturers coming out with first class, second class, and all that, they don't want to come into academia anymore. So I want to encourage you. You had a first class, come back to the faculty to teach. You can see the lab. It's a problem really we're facing, and any opportunity I have, I try to encourage people. When you groom a student who had who had been in first class position. By the time he gets to final, he will be, I want to teach. I like the way you teach. I also want to be a lecturer and all that. By the time he gets to the final year, goes to the law school, and you remind him, okay, please, let me just do 2 years practice, then I will come back. That's a point of no return. They don't come back again. But I think one way you could actually encourage, I'm talking to the bar now, from a branch to the national, you should encourage them to go into the university to ensure the welfare of academic staff is something to, yes. And I'm glad that the DG of law school is here now. Maybe when they go to faculties and they see that the welfare is not good enough, they can give what we call temporary accreditation, and that the concerned university must do this in the next 3 months, by which we will release your certificate to you. Maybe they will, and our students will now be attracted into the academia. And on a final note, government cannot do it all. So when it comes, you can see that from what we have been hearing from different stakeholders here, the DG, the professors, and so on. We've been making efforts on our own to ensure that students we produce are able to play on a global stage. They're able to make, profitability and all that. But there's something that you people are missing, or you are neglecting to do, and that's the role of alumni in their various faculties. Please go back to your faculties. Don't mind that I said that you are not playing on international stage. I know you are making a lot of money. This your branch, Eti-Osa. They are making a lot of money because there's money in real estate. Please bring that money to faculties. Come and take up one project or the other that you can do. And the law school, yes. So please, we're appealing to you. It doesn't have to be you directly. You could actually get in touch with a philanthropist somewhere you are close to, and get that person to come and do something. We're ready. If you take up classrooms in our faculties now, we're able to put your name, maintained by philanthropists also. And students will see that year in, year out. It could be a kind of advert for you or companies. Please do that, because our students, when some former student came back to say they wanted to maintain a classroom, and they want to make it air-conditioned classroom. When I announced it to the student in the class, they jubilated as if, So please do that, and I think it will help whatever effort we are making to ensure that we're able to produce graduates that will live up to expectation, both at the local level and the global stage. Thank you very much.
Thank you, Professor.
Just on a lighter note, Prof, the first class students will no longer come to academia. My take-home salary as a professor of law is 500,000 naira. End of discussion.
I didn't expect you to mention that to them. They will run away.
You will all agree with me that this session is one of the best we have had, and also the arbitration. Please celebrate all the discussants. You see, the end note on this is that please let's bear in mind what we have learned from these erudite scholars of law. When Professor Latoye was talking about the issue of first class and some other stuff, whenever I see the result of law school in recent years, and I see 60 people making first class from law school, 70 people making first class, 120 people making first class, out of 7,000 students. Yes, in my set, we are up to about 4,000 something, and we have just only 5 first class. I will not begin to wonder that is it the same curriculum, to information on like what. So that is the innovation we are talking about. And Dr. Odushot, is it Dr. Odushot? Yes, she's the one that talked about you not being complacent that after university and law school, you terminate your learning process. You will become redundant. Your brain will fizzle out, and you will concentrate on the lesser things that will not add value to you and make you to have 2 accolades, professor of law and senior advocate of Nigeria. That's the El Dorado of the legal profession. The chairman of the planning committee in person of Mr. Banji Alabi, he called me a couple of months ago when he heard that Professor Sani will be coming here, that he wants to go back to have another master's in law at his 60-something years of age after retiring from Chevron. I'm sitting down here, back to law school in Canada, writing exam to be relicensed in that jurisdiction. So we must continue to be learning. Learning is a process that must continue to revolve with us so that our life will not be moribund and our career path will not be standstill. Please let us celebrate everybody on this panel.
Thank you very much. I think the constant message from the panel is that as we continue to learn and relearn, and as we make monies outside as distinguished lawyers, we should remember the school. Let us build classrooms and provide ACs for our alma maters. Thank you very much. You can keep clapping for them, please.
Prof is asking for the YouTube link to this session. I won't pay your balance. All lawyers in Yalobakia, please. Lawyers. Yes, let's come down so that everybody will have this. Sorry. Please come, everybody. All lawyers. All law students, come. Your teacher is here.
Thank you.
Please come and join the people. Take it fast.
So please, let's proceed outside for the tea break. And as we proceed outside for the tea break, for those who have intentions of becoming, for those of you who have intentions of becoming arbitrators, you can proceed outside to the Nigerian Institute of Chartered Arbitrators stand and indicate your interest, and they will guide you appropriately. Done. We are not done. There is another session. The tea break is just for 15 minutes. The tea break is just for 15 minutes. Gentlemen, to reiterate what I had said earlier, the next session is titled The Real Estate Session, Unlocking the Real Value in Nigeria's Real Estate Assets. You would agree with me that land is one of humanity's oldest assets. Civilization has risen upon it. Wars have been fought upon it. Blood has been spilled on land. Empires have been built. Fortunes continue to be created through real estate. Our next speaker has spent years helping individuals and institutions unlock value from one of Nigeria's most important economic resources, which is real estate. And most of you would agree with me that real estate is the oil money of Lagos State, especially Eti-Osa. It is not a mere real estate expert. He is a builder of possibilities. He is someone we can say is an old stager when it comes to real estate matters. So, ladies and gentlemen, please join me to welcome the Group Managing Director and Chief Executive Officer of Alpha Mid Group, Engineer Femi Akitunde, for his keynote. Keep clapping.
Good afternoon, ladies and gentlemen. It's my pleasure to be here today. I'm an educated engineer, but I'm not learned like you. It's something that I feel is so important, and I want to thank the chairman of the branch, Barrister Obadino, who has been a friend of going to 2 decades now. When we started our company, it happens to be one of those people that we hold in high esteem. And they said that there are 4 categories of people you should be very, very close to. Number 1 is your lawyer, your banker, your pastor, and your doctor. So, Barrister Obadina has been a very good friend of our company, and we have maintained our relationship since then. So when he called me that there is this event and he would like me to talk about, present something there, and I asked him, what do you want? He said, what do I think will be very relevant to that kind of forum of elite legal professionals? And I explained to him, I said, if you look around all over the world, when they say people are wealthy, there's something that is common to all the wealthy people all over the world. When they say the royal family in England, they are the wealthiest, or among the wealthiest, it's not the amount of cash in the bank. It's the real estate asset that they sit on as a royal family. Check any rich man anywhere in the world. Real estate is one asset that must be part of their portfolio. And I don't know of any real estate transaction that can be consummated without the input of lawyers. And I don't know any lawyer that can beat his or her chest of being a lawyer that is in tune with reality and contributing value to the society that we not know about real estate. So after deliberation, we agreed what is the issue that Nigeria is going through. Why do we have so much wealth in real estate, but the wealth is not translating to value for us. It remains locked in or constrained. Like we say in the oil industry, I came from oil and gas background, by the way, before I moved into real estate. There's no amount of oil you have in the ground. If you don't bring it out, it cannot translate to dollar for you. So we said, unlocking real estate value in Nigeria is a key factor that all lawyers must be concerned with. And in my journey in real estate, I've come across lawyers in different forms, either in the financing leg, or the investment, or the title creation, or land transaction, or in the contract. Every phase you pass through will come through lawyers. So I said, apart from engineering, in fact, you lawyers are more relevant to real estate than us in engineering, because we do other things. So it's for that reason that this topic has been picked, unlocking the real value in Nigeria real estate assets. So I will talk, my talk today will be in 4 key areas. First of all, we'll discuss what really is the value and the value chain. The second one is a terrain that belongs to you. But like you say, for entrepreneurs or business people, we know a little about everything, but we're never specialists in anything. So, being an entrepreneur, I have to listen to advice of lawyers, and I have to make a decision on the ones that I feel I can agree with, and the ones that I cannot agree with. And whatever the consequence, good or bad, be prepared to live by it. My lawyers have told me, but I told you not to do that thing. I said, but I love risk-taking. I've done it. So, we will talk about a few laws that you are aware of. So I'm not going to spend too much time on those laws that relate to our industry, to real estate. And I'll talk about factors that are constraining the value, that are locking in the value, that make the value difficult to come out. And then I will end with some recommendations for different stakeholders that play in the value chain. I'm not going to blow my own trumpet. So I believe my profile is there. But I trained as an engineer. I worked for Shell Petroleum for about 12 years. I worked for Nestle Manufacturing for 5 years. And I worked in the bank as Deputy General Manager for roughly a year before starting Alphamid. So the 3 critical sectors, manufacturing, oil and gas, and banking, I've passed through them. So Nigeria does not lack real estate wealth. It lacks the machinery to convert that wealth into capital. The concept of debt capital, popularized by Hernando de Soto, describes assets that cannot be readily collateralized, transferred, or taxed because they exist outside formal legal frameworks. In Nigeria, this is the dominant condition. Over 60% of land remains unregistered. The mortgage to GDP ratio sits below 1%. Many countries, this is as high as 10 to 15%, because real estate is a store of value and of wealth. So if we are talking of being less than 1% in our own country, that is what we want to discuss today, and why and how we can lift it. Let's start with 5%, and then we can begin to grow it bigger. Property transfers takes a very long time, 60 to 90 days, and costs between 15 to 20% of property value in official and unofficial fees. We all know that unofficial fees in real estate transaction is one of the biggest problems we have. Undocumented, unreceipted, unless we want to deceive ourselves, is the reality. And it's one of the challenges that I'll talk about. The sector contributes roughly 6 to 8% to GDP, while comparable emerging markets extract double or triple that contribution. Real estate offers a hedge against inflation, steady passive income, and capital appreciation. Yet the question is not whether Nigeria's real estate has value, it manifestly does. The question is why that value remains locked. Who holds the keys to the room? And what do we need to do to collect the key and release the value? Before we start talking of value, what's the value in real estate? And what is the value chain? The real estate value chain spans from land acquisition. It starts from the land itself. Because you can only put land itself is part of the real estate. But you cannot talk of real estate without a critical component of it, which is land. Then the infrastructure on it. If you have a land that is bush and untapped, undeveloped, you can't create much value. You sell it as raw, bare land. So infrastructure that you use to lift the value of the land is part of the value chain. Then the development of the infrastructure is part of the activities that make it. Development includes design of what you want to be on that real estate, on that land, the construction, the installation of different systems, commissioning, and finally, you also talk of financing the infrastructure and financing the development work. Then there are transactions that take place there, and that is where lawyers come in heavily. Transaction from how you buy the land, how you go into JV, how you sell the land, how you buy the land, every stage of it, lawyers are there. And when you talk of the professional services as part of the value chain, you are talking of the accountants, the engineers, the lawyers. You also have tenants, administration, for those who invest to have tenants there. They are part of the value chain and the stakeholder. The talk of property and facilities management is part of the value chain activities. And you don't talk of any asset without talking of how it transfers and changes hands. Like they say, we are all passengers in this world. We will come and we will go. So one day, whatever you hold that is so dear to you, including real estate assets, you have to leave it. Either by transferring it to somebody or by way of bequeathing it as in your will, right? Or by selling it, or by death. Each of those exchanges will come as a disposal process. Lawyers are also involved in everything. So let's quickly review some relevant laws that govern real estate administration, ownership, and transfer. The mother of them, of course, is the Nigerian Constitution, the 1999 Constitution of the Federal Republic of Nigeria. It spells out everything that governs real estate as an asset. And the Constitution guarantees the right of every Nigerian citizen to acquire and own immovable property anywhere in the country. Section 43 guarantees the right to acquire and own immovable property, while Section 44 protects against compulsory acquisition without prompt compensation. So where we see some people that come around these days and just want to acquire real estate from you through other means that are unconstitutional, that the law does not understand, at that point, we run to you people to say, look, let's get a lawyer to explain to us whether the process you are trying to take to acquire this asset is legal or not. For those of us playing in the real estate space in Nigeria, either as developers or as investors, we would say that what Dangote said about businessmen applies to us more. When he said all businessmen, all entrepreneurs from Nigeria must go to heaven. And they said, why must all they all go to heaven? He said, that by the time you get there, and they are saying everybody who is an entrepreneur to this side, those of you that are entrepreneurs that are from Nigeria, this side, the rest of you stay here. All of you, entrepreneurs from Nigeria, straight to heaven. Because you cannot go to hell twice. We live in hell, those of us in real estate. If you are not fighting Omonile, you are fighting artisans. If you are not fighting artisans, you are fighting supplier. If you are not fighting supplier, you are fighting all sorts of characters. And we move from one battle to the other. The battle of yesterday is gone with yesterday. You don't know the next one that will face you tomorrow. It could be with bankers, it could be all sorts, or tax, or whatever. Real estate, because of the value it holds, it attracts the attention and interest of everybody. And if you hold something and people are not struggling with you, it has no value. So when you hold real estate asset, you must be prepared to put up sufficient protection against people who may want to take it from you. So there are a number of challenges that go with it, with the Constitution, that needs some review with respect to real estate asset ownership. I'm not going to go into all those. I'm sure they will go to distribute the papers to you. The other law that is very relevant to us is the Land Use Act of 1978. That has been extensively debated, how it has constrained the creation of wealth. Land or landed assets are massive holders of wealth. But the Land Use Act that we have currently requires a lot to be done. I can't remember now whether it's Professor Mabogunje. He did extensive work in that area to see what can happen, but I'm not too sure how much of it has been taken on board. The Act vests all land in each state in the state governor, who holds it in trust for the people. It converts absolute ownership into leasehold interest, known as rights of occupancy, usually up to 1999 years. Requires governor's consent for most transfers and introduce the certificate of occupancy as a primary title document. Yes, on paper, in reality, that is what it says. But we know that there are people in the industry, because real estate have all sorts of people, learned, unlearned, educated, uneducated. They are all part of the ecosystem. We have seen situations where CFO was issued, we acquired land, we did everything, and some people showed up and said, government does not have the right to award it, to issue the CFO. And we said, why? They said, no, it's our father's land. And they have not paid us compensation. Therefore, that CFO is invalid. In this country, do you know the law? They say he's not interested in the law. So when somebody tells you that, you need to know where your battle is going to start from. Because it's better to have gun in the hand of a trained soldier than to have gun in the hand of a madman. So when you are talking to somebody and you are not vibrating on the same frequency, you know you have a big problem. It's like you are fighting Boko Haram. The guy is not interested. He said, I don't know. And that is it. He's uneducated. He's just there to come and fight you. And he will sell the land. And the person he's selling the land to is as illiterate as he is. So the two of them didn't check anything. But the one who knows the law is you. And go and deal with it now. Maybe it's you that is talking law. These guys don't know, and they don't want to know. So this is a major issue that we have. The governor's consent takes a long, or CFO, takes a long time to process. And I'll give you an example. There was a transaction we did. You know, when you want to use mortgage requires you to have finished the development. So we got into that property. We are going to build 120 units. And we've paid all the dues. All the dues paid, including what they call CDL, that's Community Development Levy. So we went back, we said, listen, we've paid this. When are you going to do the road to this place? Over 2 kilometers to the main road. And they said, if you need the road quickly, go and do something about it. We had to cough out hundreds of millions of naira. In addition to having paid for it, we had to do the road to the place. So you finish the road. They said, where is the CFO? They said, keep building. When you get there, before you finish, we'll give you the CFO. Don't forget, real estate sucks capital. We're not talking small money in real estate. If you want to develop over 100 properties, that runs into some billions. And you take your equity, you put your debt there, you sell some off plan, and there's no CFO when it's time for you to sell to people who will need mortgage to buy. How many Nigerians will keep 40, 50 million naira inside wardrobe and pull it out to come and buy real estate? No. So, you are stranded. And for as long as that property is not with CFO, mortgage cannot be released. Something that we were told was going to take 3 months took over 5 years. And you are stranded there. This is what real estate developers go through in Nigeria today. So, why would anybody want to put money in this kind of venture? Why would bank want to lend money to the development of such kind of projects? How many minutes? Just let me know. 5 minutes more. Okay. So that is a big challenge for the industry. We also talk of the regulatory law around the environment. You've seen how buildings are being demolished now. When you are building, nobody will tell you. But of course, there are people who just believe they can do anything and get away with it in the country. And they will build, and government will demolish. So next time somebody is going to bank, that guy default, the offense of that man is going to be vested on the next real estate developer that shows up that he wants to take loan. They will say real estate is toxic. We can't lend to you. Why? They said somebody took money from us. They've demolished all the property. I'm not the one. It doesn't matter. It is the industry. We have the law relating to SCUML, which you all know now. They come after real estate developers like bees. Every day you get invitation. If it's not from Special Fraud Unit, it's from EFCC. If it's not from EFCC, as a matter of fact, if you are in the real estate industry, depending on the scale at which you are playing, we categorize ourselves as different star generals. If you have slept in EFCC, just 1 or 2 days, you are a 1-star general. If you have not gone to EFCC, you are not in real estate business. So, as an entrepreneur, it's like banking. All those big banks you see, most of the CEOs have been detained. So it's not new. Once you arrive, you roll your sleeve. Where is the room? What's the room number? Eventually, they will discover there's nothing. But before you even explain yourself, some people have taken a position against you. How can you develop an industry that way, where people are running away from? So it's a big problem. I'm not going to go through the other laws, but let me go straight to some of the challenges that we have, the constraining factors, there are quite a number of constraints. Starting from the supply side. On the supply side, we have high cost of land. Government is talking of affordable housing. How can you have affordable housing when the same government is selling land to you at unaffordable prices? It's not possible. We sell what we buy. You talk of land, I've spoken of infrastructure. If you want to connect the cities, if you want people to decongest, take the UK. People live in distance as far as 200 kilometers, and they go to work in London to and fro because the train takes less than 45 minutes. If you want to connect the city, if you want to decongest Lagos today, just connect the surrounding areas and put electricity there. More than 30-40% of people staying in Lagos today have no business staying in Lagos. They will go and live in Ibadan. In 30 minutes, they are at work. Some of us work in Lagos, we live in Lagos, 5 hours, we are not at home. So, infrastructure plays a critical role. And that infrastructure has to be developed by government. Or if government is not providing it, they have to provide the enabling environment. They are constructing the rails now. What government needs to do for transportation, mass transportation, to take a lot of cars off the road, is to provide mass transportation system, construct the rails, then privatize the provision of the cabins. So a lot of people, I mean, if you go to the UK, you see the likes of Virgin. He has his own train system. Just buy it, the wagons, put it on the road. It will convey 30, 40 people. You have taken about 5 cars off the road from one family. So we are talking of simple things that other countries have done. And we've traveled to those places and we see it, and it works. The other challenge is skills gap. A lot of people that work in our industry today are not developed. They are not developed professionals, and people don't invest in their development. We talk of legislations. Things are changing by the day. The law that you didn't know about is existing somewhere. Somebody is going to use against you one day. So it's a tough industry to play in. Insecurity is there, affecting us boldly. Then we have investment constraints, where there are laws restricting the pension funds from investing in real estate. Today, the pension fund value is about 30 trillion. Out of this 30 trillion, 22.8 is invested in government instruments, and less than 20 billion. And I'm really talking of, in the real estate space itself, 78 billion out of 30 trillion is what is invested in real estate assets. So, if pension cannot be invested in real estate development, where else are we going to get the value? Until recently, when they allow people to take 25% of their pension to buy property, to contribute as their own equity. Before now, you will work until age 55 or 60 before you build your first house. How many years remain for you? So we're saying that, look, it is my pension. You've been deducting it on a day-to-day basis. Why don't you give me a part of it while I'm still active and alive to enjoy part of it, and give me mortgage to support it? But the mortgage industry in Nigeria is very shallow. There's no money there. They are illiquid. So we know that if real estate has to grow, there has to be investment both in the supply and the demand side. Now, cost of finance is there. Cost of land is high. Cost of building is high. We now talk of people who are going to buy on the demand side. There's what we call purchasing power constraints. So what is the disposition? What is the disposable income of an average Nigerian? When you need to buy food, you need to fuel your car, you need to pay for transport, you need to pay your children education, how much remains for you to own a home? And even what we are talking about is interest that is unaffordable. you're talking of about 30%. So if you take a loan of 10 million naira, your repayment is about 275,000 naira per month. What that means, according to Nigerian law, is that you cannot spend more than 1/3 of your income to pay for any debt. So 1/3 of that, 1/3 of 289 is about how much? Times 3, that's 1 million naira. You must be earning 1 million naira. If you don't believe me, check. I asked ChatGPT today, just today as I was coming here, because when I did a small calculation, I said, can you tell me how many Nigerians, what percentage of Nigerians earn 1 million naira that can afford this kind of loan? To pay 285,000 naira per month as loan repayment. It says it's less than 5% of Nigerians. Less than 5% of Nigerians earn 1 million naira a year. I said, okay, check for me, 500,000. Then the number increased to 8.5%. So we all wear suits. We look good on the road. We are poor. We are really poor. So don't let anybody deceive you. Nigerians are going through a lot. And what I want to tell you is that for this to work, government has a lot to do to improve affordability, accessibility, and availability of housing for Nigerians. So I will not go too much into other details. I encourage you to go through the paper. But I want to say that a lot of work has to be done by the government to take a second look at some of the laws guiding real estate transaction, infrastructure development, financing, investment. Banks are the only ones declaring 6 trillion, 7 trillion per quarter. Every other industry, they are declaring losses. Real estate, capital tied down. By the time you finish one development, 2-3 years, at interest rate of 30%, all your profit is gone. Real estate is like aviation. It's not profitable. When you see an average real estate developer, many times it's not like they set out, because you lawyers are here, it's not like they set out deliberately to defraud people. I read the news and I see all sorts of things happening to people. You just have to understand that they are dealing with tough situation. I will end this talk, just 1 minute more, sir. Giving you one story. Something happened to me 3 years ago. We were going to do a development and we needed capital. So we were taken to one of the pension funds. So when we entered, 3 young men came in and they sat in front of us and they said, yeah, we've been told that you are coming. I said, yes. He said, you need some funding? I said, yes. He said, well, we don't like real estate. We can't invest in real estate. I said, why? He said, it's too risky. It's too risky. Okay. So I now asked him. I said, I'm sorry, I want to ask you some very personal question, and I will appreciate if you can answer me honestly. I said, do you live in your own house or you are renting? He said, in my own house. Okay. Where am I going to get money to hold? I'm renting now. I said, okay. So it is for people like you that people like us are doing what we are doing. Because if we don't go out there to look for fund to build for you, you cannot afford to use your money to build. So for how many years do you want to continue to rent? He said, as long as the time permits. They didn't give us the money. We eventually had to go and take very expensive, finish the project, and we invited him to the launching. And the day he came, the food we offered him, he couldn't eat it because I was watching him, whether I was going to eat the food. He didn't eat the food because he didn't believe the project would be doable. So on this note, I'd like to say that a lot is expected from government. A lot is expected from professionals like you as lawyers. A lot is expected for those of us that are engineers. A lot is expected from the financial institutions to take a second look into how we're going to make real estate more affordable, and in a manner that wealth will move, will transfer, right? Because when you have wealth that is locked up somewhere, it's not multiplying. It's only when wealth transfers from one hand to the other that people can contribute their own value, their own intellect, their own talent to it. So if I keep 100 naira here and it doesn't move from one hand to the other, that 100 naira remains 100 naira. But when it moves from person A to person B and he uses his own talent, that 100 naira becomes 120 naira. It moves it to the next person, to the next person. That is how wealth is created. But unfortunately for us, here, a lot of our wealth are locked in the real estate space, and unless government does what it needs to do, and all the other players in the value chain do what they need to do, that wealth cannot be multiplied. It will remain stagnant and locked up. So thank you very much for your time and attention.
Thank you very much. Please keep clapping until he takes his seat. You would agree with me that it was an insightful keynote. And I would like to call on the chairman of the branch to appreciate him for his efforts.
Thank you, Mr. Secretary. The engineer, Femi Akintunde, on behalf of the Nigerian Bar Association, Eti-Osa branch, I appreciate you that at a very short notice, we approached you for this initiative and you accepted of it. Even when I spoke to him about it, I saw the passion and the level of erudition that he has on this sector. And I was wondering that you are a facility manager before you is a petroleum engineer before he diversified into facility management and later became a big name in the real estate world. So I told him that day that, sir, this thing you are saying you don't have time that you will not be able to do, you will do. Because if I knew that you are going to say this much, I will have screen record our conversation and just bring it to this event and play it for people to see what you have said to us. And why I'm able to drag him to this place is because I have a relationship with him. When I became a young lawyer here in Lagos, posterity brought me in contact with him. Somebody was having a transaction with him, and the person messed up. He was looking for someone that would help him to come and say something to cover up his track. So they now went to his office, and they gave me lift from a Kota shopping complex. On getting to his office, the person that they brought to come and remedy the case, he came and demarcated the entire thing, messed it up beyond normal. And that was where I was sitting as a visitor. I just said, can I say something? He said, yes, go on. And I interjected, and I was able to give a clearer feel on it. And he said, you must be a lawyer. I said, yes, and that's how we started. He took me down to their corporate office to meet with the company secretary, and it's over 17 years. That was 2009 that we met, and the relationship has been there. For the first major millions I made in Lagos, it was through his office, Alpha Mid. To be called upon to close a transaction on the 28th of December of that particular year, and you were paid something in the region of 10-15 million naira. That's a success story. Mr. Akintunde, we are grateful, sir. And I know that for quite a lot of you that are listening to him, you will know the quality of what he's made for. And as you know, sir, this our General Secretary, Peter Nlenwa, is handling a case for Alpha Mid. This is him, the moderator of this event. Here. He's one of the lawyers that is representing Alpha Mid. So when he heard that you are coming, he said he's been representing your company and you don't even know he exists. So that's Peter. Thank you, sir. We are so grateful, sir.
Since the chairman had made major millions from Alpha Mid, I believe everybody in this hall will make major millions today. I'm not a prophet, but I see things. So you'd agree with me that property is where law meets economics, where regulation meets investments, where rights meets responsibilities, and where national development finds its strongest foundation. Our next panel brings together experts who understand these realities from different perspectives, and that will help us to explore only the challenges before us, but not only the challenges, but also the opportunities beyond those challenges. So in order to speed up on this session, I'll go straight to calling up the panelists. Just give me a moment. So quickly, I'll be calling up, the panel session is to discuss on the keynote, which is unlocking the real value in Nigeria's real estate assets. So the first on the list that I'll be calling up is Bartholomew Egbochie, the Group CEO of Atco Homes. I understand that he is not here. So the next on the list is Mrs. Emike Untiokiet. I believe I pronounced it very well, from Metro Smart City. Please keep clapping until she takes the stage. We have Mr. Daniel Onwuzuka, National Sales Manager for Brits Properties Nigeria Limited. Keep clapping until he takes his seat. We have Prince Adeleke Ogunbowale, the MD and CEO of New Map Realtors. Keep clapping until he takes his seat. Then finally, we have Mrs. Olorunfemi, the Director Legal, representing the Honorable Commissioner for the Environment and Water Resources, Honorable Tokumba Wahab. Keep clapping till she takes her seat. The superintendent for this session is Onyemauche Ibezim, a senior associate of Kenya.
Good afternoon, everyone. I want to start with a short story. My father told me that he had an uncle who had a child, and at some point, the lady had to go to school, but there was no money to send her to school because of how expensive education recently is. But then, he had an asset. He had worked all through his life to build a property. But he wanted to use the same property to get a loan from the bank. But when he got to the bank, he found out that his asset had no value. That is the reason why we're here today, to discuss how we can make use of the value in the real estate industry. And I have a very rich panelist, Mrs. Emike Ntioket. She is the head of marketing for Metro Speed. And just to mention that Mrs. Emike is currently working on a very beautiful project in Lekki Phase 1 on behalf of Metro Speed. The project is called Metro Smart City. She will be sharing insight from her experience in the real estate industry. We also have Mr. Daniel Owozoka. Mr. Daniel Owozoka is the National Sales Manager for Brit Properties. And please permit me to mention that Mr. Daniel is also working on a very beautiful project at Sangote. The name of the project is Fruit Vine, and he's working on that on behalf of Brit Properties. He would also be sharing insights from his experience in the industry. And on my left, we have Miss Prince Adeleke Okumbawale. Prince Adeleke is the CEO and MD of New Map. Prince Adeleke also has a beautiful project called 11 Body Lawn. That's a heavy name. Prince Adeleke would also be sharing insights from his experience, very large experience in the real estate industry, and Mrs. Olorufemi, representing the Honorable Commissioner, Mr. Tokumbo Wahab. Our own Mr. Tokumbo Wahab will be sharing insights from the regulatory aspect of the Ministry of Environment and Water Resources. So please, I'd encourage you to pay attention, and I'll use this opportunity to appreciate Engineer Kitunde for the keynote speech, very wonderful speech from Engineer Kitunde. We appreciate you for setting the tone for this section. And just to mention that when we were sitting, Mr. Onwozoka actually told me that I can call him Daniel, please. When I call him Daniel, don't be offended. The people from Brit, he permitted me to. And Mrs. Ntioket, even though I pronounced the name well, she said I can call her Emike. Please, Metro Speed, don't wait for me outside. She permitted me to call her Emike. So Daniel told me when we were sitting that Engineer Kintude has dealt with everything. That there is no need for the panel section. So that is to show you the value of your speech, sir. And I told him that you are just setting the tone. We are here to give our perspective on the other issues. Thank you so much. So I'll encourage everyone to please pay attention and reserve your questions. If you want to ask questions in between the section, you can write it down and send it to me. But the question and answer section will be taken after this section. And I'll start with a general question for all the panelists, and please permit me to give you 3 minutes for that answer. Looking at the real estate industry today, what do you think we can do? What is the biggest challenge that the real estate industry is facing today? And please permit me to start with Emike. Do you have a microphone?
All right, thank you so much. Good, I don't know if you still afternoon or evening. Really honored to be here. So going straight to the question, I know that our time is fast spent. I would say the biggest challenge I see will be investors' confidence. So it doesn't matter if you're speaking to someone locally or internationally, just being able to give them that confidence and certainty that the land title documents they have is original, or that the infrastructure the developer promises to deliver will be delivered. You know, that's one of the greatest challenges. So investors buy confidence. You know, it's not really about the English you speak or how beautiful your edifice is. Once we can get that right, capital appreciation can come in and there'll be valuation for the economy. Thank you.
Thank you very much. Yeah, Daniel, please, go on.
All right, good afternoon. Thank you. I would say setting in structures, right? Structures and regularization or regulation, proper regulation in the industry, right? I would have said finance, long-term finance that does not appreciate or does not incur a heavy interest rate, However, that can come in, and if the proper structure is not in place, everything will just crumble. So when I say structure, I'm talking about from, how the documentation process, the length in which, you process your document from, the title it is to C of O, just like engineer said, even down to the agencies, how much they collect for agency fees, rental, how they set prices for rents, how they generally set prices. If there are proper structures to check in this place, then I think, yes, it will, have a great impact in the industry. Yes.
Thank you for that contribution. Yes, sir. Mr. Gombawale.
Please, the question again.
Okay. The question is, what is the biggest challenge facing the real estate industry at the moment?
Okay. I think the big elephant in the room, my big bros, have spoken a lot about those things that we face. But all hopes are not lost. We are here to take the bullets for you, and we'll continue to do our best considering the shortfall in property to the population of the country. A lot of things have been said about challenges, but at the end of the day, there's light at the end of the tunnel. Of course, we do a lot of transactions that doesn't fly well. Some do. We are able to augment some of these things. The property market is big enough, and our major problem, we need to put structure in a lot of things. We need to talk to... One thing I didn't hear Engineer Kinsley talk about is the fact that the rate at which government itself shift the post is a big deal. Just 2 weeks ago, they sent us a bill on what it will cost us to document our properties. It's astronomical. So those are some of these things. And we talk about all bystanders coming into the business. I've been in the business since 2008, a year before Engineer Akintunde met the MBA chairman. So that's about 18 years that I've been in the business. So we've seen a lot of things coming in as much as the property market is evolving. In Nigeria today, we are not doing badly. We can see properties going up just across the water here. So considering that Nigeria is a top 10 upcoming market, upcoming economy in the world, especially Lagos. So we are actually doing well, but we can only encourage that a lot of challenges, but please, in advising the government, thank God we have a government right here, in advising the government, some of these problems, they should help us look into it and bring some succor to make us be able to achieve bridging the gap in the shortfall in the housing shortfall in the country. So documentation, as I said, is a big problem. So that's one of the things I didn't hear him mention, which is very important. And this has to do with lawyers. It's your field. The last time we had, what's it called? The House of Assembly, the town hall meeting. The lawyers' contribution were quite paramount and important to the planning of the state. So these are some of those things we would love to mention. If you are even giving us a time, in 3 years we are going to increase this, it still makes us, it gives us room to plan. But if we don't get some of these things, at the end of the day, the clients will suffer for it. Because if my projection is not met, your own bill too will have to go up. So those are some of those things that we face.
Thank you very much, sir, for your contribution. Sorry, just before I give the floor to Mrs. Olurunfemi, I've been in several public gatherings. I never knew that I would be the one announcing a car someday. So please, I'll have to follow the format that I've always seen. If you are the owner of silver color Honda Accord, Ekpe 487EA, Ekpe 487EA Honda Accord silver color, please, said your car is on fire. Thank you. Sorry, Mrs. Olurunfemi, how do you want to share your perspective from the regulatory side? What is the biggest challenge? Most of the comments from this side have mentioned the government. So what is, and we're happy, and just to mention, let me use this opportunity to appreciate the Honorable Commissioner, Mr. Tokumbo Wahab. We're seeing everything he's doing on social media, and it's very wonderful. Thank you so much for that. So what's the challenge that you could see from the regulatory side?
Good evening, everyone. Thank you for the opportunity. The challenges are vast and multidimensional, but as it relates to the ministry, we cannot overemphasize that the issue of compliance, people are very reluctant to comply with the regulations. And where people dodge, partially fulfill, avoid, complying with the regulations as set down, eventually they will run into a brick wall. So there must be compliance. There isn't quite enough compliance. Some companies do comply, but as stated by my co-panelists here, there are some cowboys that have infiltrated the domain, and compliance is an issue that must be dealt with. There's no option. Another issue, also part of compliance, is encroachment on drainage channels and setback. A lot of people, they have a laissez-faire attitude that it's just water. It's just a little water. But what they fail to realize is this person comes, encroaches on, when I say drainage setback, aside the one that we see on the roads, we have the bigger canals, they're all drainage. So when you have people encroaching on the drainage setback, what it does is to impede the free flow of wastewater. The consequence of that is that there will be flooding. And when there is flooding, it will also spill over to so many areas of our lives, endangering lives, causing delay in traffic, and at times it may even lead to collapse of buildings, where buildings are perpetually soaked in water. Definitely something will give way. And also, for those who are in the sector that constructs multi-dwelling residents, developers, quite a number, maybe they are not aware, or maybe they choose not to be aware, they tend to ignore the need for the environmental impact assessment. When we're talking of environmental impact assessment, it's not just the environment as we see it. When you have an expanse of land and you want to build, let's say, 50 housing units, you have to consider the impact that the wastewater from those units would have on the surrounding drainage. You have to look at the impact those new buildings will have on the transportation system, on the electricity system. It's all part of what we talk about. But more particular of interest to the ministry, the environmental impact assessment will assess the consequence of building those numbers of units on that space of land, because there will be displacement. That's what I mean by environmental impact assessment. We need to know so that we can help. Ours is to help. It's not that we are constituting a clog in the wheel of progress. No. But if you can get it right from the foundation, as you move on, then you will not have too much of a problem. But where the foundation is faulty, where you haven't taken these things into consideration, it will have spillover effects. And when it has spillover effects, the government will have to look into it, because other people also have a right to live in a safe environment, free of fear of flooding and things like that. And then another issue is, this is quite common, where approval has been given for a specific purpose. And then you have illegal or unauthorized conversion of property. For example, there's approval for housing, residential. And somewhere along the line, you know, our people, they start converting the ground floor from residential, maybe to office space, to commercial. All those things have spillover effects. So it's important that people comply with the regulations as laid down by the government. Thank you.
Thank you very much, ma'am. And this is actually the beauty of having the regulator on panels discussing issues like this. And I sincerely appreciate the Nigerian Bar Association, Eti-Osa branch, and the chairman for making this happen. So you've actually set the tone for my next question, which I would start with you. You've mentioned a lot of things: drainage, setback, flooding, environmental impact assessment, commercial to residential. In all of these issues that you mentioned, if you check, when we were also discussing on this side, we were pointing fingers at the government. And it is very easy to point fingers at the government when we forget our own responsibilities, right? So I would want you to touch on the issue of flooding. Can you lay more emphasis on the issue of flooding? Because that's one of the issues that Lagos State residents are facing at the moment. What is the government doing about that? And what do you expect us as residents to do? Thank you.
Thank you very much. I'll split the question into three parts. The first, the responsibility of the government. What the ministry does, there is an Office of Drainage Services. Part of its ministerial responsibility is the clearing of drainages, the silting of canals. You will notice or observe that there are drainages that are, when I say lined drainages, it means those that have been sheet panel of concrete. They've been lined with concrete. You would notice that for some strange reason, people will empty the refuse into these drainages, thinking that when water comes, the water would carry it somewhere, far away. Where you have people using the drainage canal as a means of getting rid of waste, it's not going to flow anywhere. It's going to get stuck at a junction. When it gets stuck at a particular junction in the drainage system, it will spill over and become a problem. Because when the rainy season starts, the drains will overflow onto the streets, from the streets into residents of those nearest to that drainage issue. But the ministry does periodically, and especially rainy season, just prior to the beginning of the rainy season, we'll go around and try to clear all these refuse including plastic bags, household refuse. Some people will just drop things. You'll be amazed what people drop in the drainage. But more particularly, disposable plastic bags, they constitute a major waste, a major problem to free flow of wastewater in the state. Another issue that we have is people building on the drainage right of way. When I say drainage right of way, is equivalent to the streets, the road that the water will pass through. That's the drainage right of way. Where people have been given or they've purchased and they know where their land ends, but for some strange reason, they try to extend for a few feet and they encroach into the drainage channel or they build on it. The consequence is that the water will not be able to flow, the wastewater will not be able to flow in the drain. And you cannot say that it is normal. The government has a responsibility to everyone to live free of the fear of flooding. The fact that you have a land near the drainage does not permit you to extend your building into the drainage, preventing the free flow of water and endangering other people's lives, endangering innocent people, law-abiding citizens from having access to their roads, to their homes without fear of flooding. So that's what we've been doing.
Thank you very much, Ma. Please, I'll still come back to that question because I really wanted to find out what exactly it is that the ministry is doing to that effect. But I'll just quickly move to Mr. Gumbawale. We are talking about unlocking the real value of real estate. How do you see land administration? You can use Lagos State. You can use Lagos State as a point of contact. How do you see land administration? And I would like you to lump the answer to the two questions together. What are you proposing? What is your proposal to deal with the issues surrounding land administration in Lagos State?
Yes, I need to probably give kudos to Lagos State pioneering the computerization of land administration. Because if you visit other states, you will know how difficult it is to document your land. A state like Ogun State, just beside Lagos State, is close to impossible to document properties on time because they've not learned anything from what Lagos State is doing. I remember in the second administration of Governor Bola Tinubu, when our paper documentation was being converted and being computerized. I remember it was quite hectic, but it's counting for good today because the issue of documentation is actually getting better. Just as I said earlier, the rate at which they shift the goalpost is really unfortunate. Recently, when you want to have a survey, they came up with something like a vector, a new software called Vector, which is causing a lot of bottleneck in your documentation. But be that as it may, we can still give them kudos, but we need to speed up the time of documentation. We have to advise them to speed up the time of documentation. It's been terrible lately. Just as I said, I don't know what they think about. Before you know, this administration is getting it right in some aspect. The next administration may not even know what to do. There's a point in Lagos that we do documentation in months, but now it's a big challenge. It's a very big one, from one bottleneck to rectification to survey rectification to, so it's been so hectic. But I understand the fact that they are trying to comply with the standard as it obtains in the world today. But other states, they are not even doing nothing, To a lot of states, they still do paperwork in black and white, in papers and all sorts. So Lagos State, kudos, but they just need to try and help in facilitating some of these things quite early. Because by the time developers like us do develop and want to sell, it's a big challenge that in 1 year, 2 years, your document is not out due to some flimsy kind of excuses that is not probably heard of. You keep repeating the same thing and every time. So they need to actually wake up and try to facilitate this thing on time. We understand the governor of the state that used to work with LSDPC, but he needs to find a better way for some of these things so that it doesn't affect us. We have a lot of challenge with timing of documentations.
Thank you very much, sir. Very good point. Timing of documentation. It's good that we also have the regulators with us on the panel. They are hearing you, sir, loud and clear. So I would ask Daniel, there is this buzz around how expensive it is to get a home on the island, right? And you have any ideas about how we can build sustainable models of housing that low-income earners, average income earners can be able to afford a home? Do you have any ideas on that?
Okay. So, if I get your question right, there's a buzz around, the island being unbearably expensive, right, to live in. Whether you're buying a home or you're renting, I believe, right? Okay. In economics, it's said that when supply, it's less than demand, prices, it affects prices. Yes? The island is, for many people, an opportunity to change their financial situation, right? Because they believe it's the closest, living on the island is, closest to where they can, get more businesses and, sell at the prices they want to sell when you're talking about entrepreneurs and business persons. However, there's just been a cluster of the population around popular areas, areas such as Via, Ikoyi, Lekki, Ikate, down to Ajah, Shongotedu. And everybody wants to just live around this cluster. Whereas we have, hinterlands such as, Ibeji, Lekki, Ebe, the refinery axis, Elerongbe, right? These places, it's termed as the new Lagos. And then we have affordable lands there. As a company who sells, we do site and service, Brit Properties Nigeria Limited. We've sold lands for several years in these places for as low as, I mean, in some cases, we sold land as low as 500K per plot, right? So it gives whoever it is that wants to start building easy access, to purchase land and, do whatever you want to do. However, there are cases or there are reasons why they cannot build there. Number one, security. Two, as the engineer has rightly said, the lack of infrastructures in these places. So if, the government, installs infrastructures in these parts of, Lagos, or the island rather, and that enables people who live in the area access to good security, commercial hospitals, and all that's needed for them to thrive. It declutters these areas that are already, overpopulated. And just like the engineer said, there are parts of the Western country, even Kenya, for example. Kenya recently saw a rise in their real estate. Why? Because they connected urban areas, they connected their rural areas to the urban areas through railway systems, right? So people can live as far as, and then, find a way to commute down to their work areas or to their business areas just by connecting a railway system. Yeah, and yes, there's also a buzz that the government is also trying to install this, and if it's done expediently, then it will help declutter areas. And then you see that whatever buzz that's going around about Lekki being expensive to live in will change, because now people can now live in Ekpe and commute down to VI, for example, and the rental value will significantly drop. So it's because of the scarce housing that has caused rental and housing options to go up outside inflation. Yes, so for me, I'll say this is it.
Well, thank you very much, Daniel. Very good point. Promoting the new Lagos. You said two things, two very important points. That we as residents, we should not always aim to be within, to cluster around here. We should try the new Lagos, and the government should also try to develop the new Lagos and make it habitable for people, right? But I want to link it to my second question for you. But before I go there, I just want to say something on a lighter note. Maybe people don't want to leave Eti-Osa. They want to be part of the Nigerian Bar Association, the Eti-Osa branch. So, but I just want to help them to see you can also go to the new Lagos and be part of the Eti-Osa branch, right? The new Lagos. So, my next question is, how can do you think mortgage is going to solve the problem for the housing problem in Lagos? And since you're a very good promoter of the new Lagos, you can use it as a point of contact.
All right. Yes, mortgage is going to help a lot. I mean, I'll again mention what engineer said. He gave us data on what the earning power of the average average Nigerian is. And with such earning power, who can build, a bungalow? Let me even use a 2-bedroom flat with how much they earn per month. It's going to take years, because on the hierarchy of need of the average Nigerian, he just wants money to eat. Simple. Before you now to talk about, building a house and all that. Although it's his dream, but, oftentimes those dreams are more or less like wishes. So, where the mortgage system comes into place, it allows or enables, the average Nigerian to spread payment for as long as 20, 25, 30 years. Just like what they do in the rental system. The average Nigerian pays rent, and the federal government has done a rent-to-own scheme, sometime in 2018, around Abuja and some parts of Lagos. And it worked successfully. Why? Because it allowed the average Nigerian pay either monthly or yearly for this long time. So they can be able to be paying for whatever house they're living in. So the house is already built, and they move in and they're paying yearly or monthly. and then also can eat and afford other amenities. Because based on data we've gotten as marketers, right, we see that they want to own homes, they want to own lands, they want to own properties, right? But their pocket is disagreeing with them. So the little they earn, they would rather just use that to survive because of the fact that they don't know tomorrow. My fellow panelists have said something. The government moves the goalpost of, certain things every once in a while. And you cannot tell what inflation is going to look like by 8 p.m. today. So it's not even tomorrow. By 8 p.m. tomorrow, you don't know what inflation is going to look like. So whatever amount you have in your pocket, you want to safeguard it because when it hits you, you want to be able to even see 2 or 1 square meal a day, right? Not to talk of buying or paying for land. But yes, they've made things happen for themselves. Nigerians are very resilient people, very hardworking. They find a way to, make money regardless and, afford this thing. So if they have a way to easily own homes, across longer duration, they will make it happen, and it will solve the housing needs. So yes, mortgage is very, very, very crucial, to reducing the housing deficit in Nigeria.
Thank you very much, Daniel. You have actually just led me to my next question for Emike. You have a very beautiful project coming up in Lekki Phase 1, which is the major hub of Eti-Osa. The actual real meaning of Eti-Osa is like the commercial hub. So you are the center of everything. And there is this buzz online about how expensive it is to acquire properties within that vicinity. And then a lot of people are saying, oh, I'd rather just go to London and invest. I'd rather invest outside than invest such huge amount of money just buying a small property within that area. So what do you have to say about it?
So that's a very, very interesting angle to come from. Daniel said we should move to Ekpe and Ikorodu, notwithstanding where we work. But I think from that angle, when people say houses, particularly situated around the Lekki Phase 1 axis, are very expensive, what I try to ask them or let them understand is there's a difference between price and value, right? So before you say properties in a certain location are expensive, there are certain things you should ask yourself. What is making it look expensive? And expensive is quite relative, really, because despite the concerns that tend to come up, we still have a very high demand, for these properties. So what are the things I would rather place? I'd rather focus on valuation. And I'm looking at things like location. Is it specifically located in a place where 5 to 10 years, the returns on investment would definitely go up? So you look at location, you look at the infrastructures as contained in that environment. Does it give that difference between property A and property B? I'm looking at what basically makes that place stand out. So not to negate the place of foreign policies or foreign investments or houses like we have. Yes, they have their own place, they have their own parts, and they have their own benefits, but I can still confidently say Lagos State still has one of the most vibrant real estate opportunities, so just looking at those key factors as listed are things that differentiates pricing from valuation. Thank you.
Okay. Thank you very much, Emike. And just about to move me to my next question. What do you think the government can do to help that issue of pricing? What do you think the government should do?
Issue of pricing. I'm glad we have the government represented here. My fellow panelists, I think, did a lot of justice to that. I'd say if we can look at, or if the government can help us look at smarter land documentation processes, faster approval processes. He also spoke on I don't like to use the word bills that keep coming, but they can actually look at the financial aspect also. A lot of this will help, especially when we're looking at bringing in investments into the country.
Thank you very much. Very good points. Smart approvals. This actually the last question for all the panelists. If you have an opportunity to implement one reform for the real estate industry, what would that be? And I'd like us to also touch on issues relating to technology. Thank you. Sorry, Emike, you can start.
Okay, so if you want the government to help, sorry, what was the first part of your question again?
So the question is, if you have an opportunity to implement one reform.
Okay, implement one reform.
Yes, one reform. What would that be?
One reform for me would be, I'd say it's between implementation, it's between execution, it's between policies, creating the right policies. But I'd rather go for execution, because the truth is we keep having policies come out day in, day out. So I don't think it's a issue has to do with a policy concern. I would rather go for the execution bits. So if we can start to execute a lot of these policies that we put out, that's from the government's angle, it would be great. Then you spoke about technology, and I think I brought that up briefly. Technology integration is very key for us where I work, and that's why we have the Metro Smart City coming up, because we feel like we're at a point where developers need to start to think out of the box. Let's not keep doing the same things over and over again, and it looks like nothing much is changing in terms of, like you said, expensive places to live, and they're giving you just the basics. So technology integration, fantastic. Like I said, smarter systems, faster approvals would be great. Integrating AI into the very fiber of what we do. Because whether we like it or not, the world is changing quickly, even for living conditions and real estate. So the future is here. The future is talking to us. And cities are where these conversations will start to be very visible. So let's start to do a bit more AI integration into our living systems. I can confidently tell you briefly that one of the things we've implemented as a future forward-thinking company is, for example, the digitally accessed layout plan that can be obtained online. So it simply simplifies the process. You can go online, you'd see the available land plots, you see the unavailable land plots, you can pick the land plots you want, make your payments there online, get your offer letter, get your allocation letter, and everything is streamlined. What does that do? It ties us into the Nigerian market and the diasporan market. We don't have to walk physically to my sites to do site inspections, because there's AI integrations, there are virtual tours, so it's a lot we can incorporate technology-wise into our regular developments as property developers.
Thank you, Emike. Very beautiful project by Metro Speed. Daniel, please.
All right. I'll say for me, the reform is to be considering the demographic right now that have the earning power to purchase properties, right? I'll say digitalize the whole system so that the ease of doing business is increased. And I'll give an example. So you want to verify the title of a property. Say you've seen a property, like the process it takes you to verify that. That's if you even get the correct result it's a whole lot, right? So I think there was sometime in 2023 in one of real estate conferences somewhere at Eti-Osa, and His Excellency, Mr. Hamzat, came and he promised that most of the documentations were going to be, onboarded online so that you can access it through a centralized system. Hopefully that comes into place so that, from your home or, from where you're standing with the marketer and you want to purchase land, you can confirm and, finish up business that day. So that business is that day and the next day you do other things. So I'll say digitalizing the whole system that incorporates documentation from the government parts. And even on the real estate companies on their own parts, they should also incorporate technology into how they do business. On our own parts, we're also doing that. We have an ERP system, just like my fellow panelist says, from, say, for example, the project we have facing the Monash Road, Fruit Vine, we have offline projects. And you can, from our website, purchase, get your receipts, get your documentation done. We're still finalizing on that, but we want to make it as easy as from the comfort of your homes, you've done business, and you've moved forward to other activities of the day. So this would be the reform I'll put in place. Yeah.
Thank you very much, Dana. Very beautiful project by Brits. Prince Gumboale, what reform would you propose, sir?
To come to the reform, I want us to know that real estate as a whole is relative. I could see my sister doing Lekki 1, I can see my brother doing Ibeju. I do Ikoyi, and of course our regulator is here. What we are trying to create is a balance between every strata of the society. My target audience, I'm in competition with Paris, I'm in competition with Manhattan, and probably some other places in the world. Taking a look outside here is one of the biggest real estate in Africa. So we need to create a portfolio that our people in the diaspora, of course, a lot of Nigerians have houses in Manhattan, in France, and probably in the biggest real estates in the world. We are trying to bring them back home. But if there's no technology to back it up, you need to be able to check what you are buying from any part of the world. So we will appreciate if the state government can step up real big. I know Lagos State is doing well. They need to step up and help in terms of documentation, verification, in terms of how it's been practiced. Time is of essence. When we try to build in other parts of the world, we see that documentation is not as hard as we have it here. Here, the bottleneck is something else. So we appreciate if the state government can step up some of these things that has already been mentioned. Time and, of course, issue of verification. IT, or probably IT is the in thing, cyber and all sorts. So please, we appreciate if they can step up their game so that we can have a seamless situation in trying to bring these dollars back home. Some of us that our target is to bring some of these dollars back home and compete with the biggest real estate in the world, as the case may be.
Thank you very much, sir. Very good point that you have made. Let us invite our brothers back home. Build cities like the ones outside the country. Mrs. Olorifami, you've heard everything that we have said. The call to government. Where will the government help? What will the government do for us to help us improve the real estate industry?
Thank you very much. My co-panelists have said a lot extensively on what the government is doing presently. The Office of the Surveyor General of Lagos State and my colleague at the, I don't want to slander your name, so let me just, Emeke. But one thing that I've observed is that people fail to realize that those who are giving the government the information to file, they have a responsibility to be honest in providing the facts and the information that is true. Problems will arise and do arise and will continue to arise in as much as people who present facts to the government have been economic with the truth of what they have presented. There are so many instances that Mr. A will bring this information for filing. At the end of the day, the information that has been brought for filing is not a true reflection of what is on ground. So it's not just enough for the government to improve. Yes, government has its own responsibility, and government is doing its own part by ensuring the review of the laws, making sure that things are simplified. But the most important thing that people have not mentioned is the responsibility of those who are providing the information to government to file. If you bring false information, if you bring information that's not quite a true reflection of what is on ground, anybody that goes to that system to try to get information out of the system can only bring out information based on what was supplied by those who have brought the information to be filed. So as individuals, as corporate entities, we have a responsibility to ensure that the information we present is a true reflection, an honest fact of what is on ground. Once we can get people to do the right thing, I'm sure we will move much faster. Thank you.
Thank you very much, Ma. We have come to the end of the section, and because of time, we will not be taking questions or comments from the crowd, but you can actually meet any of the panelists. The chairman has graciously granted us an opportunity to take one or two questions from the audience. So, do we have any questions, please? Okay, thank you, sir. So please help us with your name and your question, sir.
My name is Ita Effiong Umium. Umium is spelled U-M-I-O-M. My question is with regard to title, transfer of title. As a developer, when you develop units, you sell it to third parties or to sell it to your client. If, unfortunately, your client pass on and leave the wife, and the wife want to sell that property, and you know the property document where the date of assignment was in the name of the husband, late husband, and unfortunately, the woman doesn't have money to process letter of administration, as in regard to the value, because the value of the property will be charged as in 10%. Please, as a developer, what will you do to assist the widow to transfer the title of that property to sell it? Thank you, sir.
Thank you, sir. Who is your question directed to, sir?
So the panel, the developer, sir.
The developers.
Yes.
Okay. I think a lot have been said about arbitration earlier. So it's because in most cases when the husband was buying the land, the final documentation has not been perfected in the husband's name, which is probably the governor's consent in most cases. So in a situation like that, everybody comes to the round table and discuss further with enough witness to sign on behalf of the wife. So an issue like that happened, of which the wife and the husband has been the one visiting the property while we were building. But in the unfortunate incident of the demise of the wife, there was enough evidence and there was enough reason for us to allow a seamless transfer to the woman, having signed every document that might come back to us. So it was quite seamless, because in that case, the husband made a deposit of almost 70%. Since the woman couldn't go ahead, we have to refund that money at the time while the property was finished. So we have to refund our 70%. So most of these things, we have to put human face into it. If you are coming to collect your 70%, of course, a lot of meeting happen in the process, hoping that nobody will come later to come and claim that my brother had stuff like that. So all those things, we put a lot of human face into it and tidy it up with the help of our legal team.
Okay, thank you very much, sir. The next question will be taken. Okay, sorry.
Good afternoon, sirs. My name is Kemi Ogunanki. Please, my question is to any of the developers. In situations where a client purchases a property from the developers and they are just starting to build, and gradually they now said because of the situation in the country they cannot continue, and they now start tossing the client to and fro. My question, I've had about 2 clients, 3 actually, 2 from outside the country, and it's not speaking well for us. My question now is that, is there a regulatory body among you regulating the developers that could sanction such people that will collect money from clients, and then they will build it to a certain level, and then they will go and start another set of projects somewhere else. They will not finish the ones that they've collected money from. They just abandon them. Is there a way, like NBA can sanction, lawyers, we have regulatory bodies. Can you sanction yourselves? Thank you.
Thank you for that question, ma. I remember during COVID-19 in, what's it called? The 2020 thing.
Yes, 2020, 2021.
Yes, 2020, 2021. We had to review a lot of our prices. Hello, madam. Yes. In 2021, in 2020, you realize the fact that the inflationary thing that happened at that point brought cement from maybe 850 to almost 4,000, maybe from 2,000 to 4,000. So at that point, we have to invite all our subscribers and let them understand that we will not be able to cope with this inflationary thing, and everybody saw it. We had 70% response in trying to structure the payment in such a realistic way. We made a lot of losses, just like the person that gave the keynote address, Engineer Kitunde, said that we run a lot of losses. I understand they develop. It's a crazy world out there for us. I understand the developer arguing on maybe phase 1 and go and start phase 2 because he has sold phase 2 at the right price. It's understandable. Please bear with them. They will always get a human face. If the project was supposed to take 2 years or a year, you people will negotiate all over again and see what you can contribute, if you know what I mean, ma. So that's the best way to go about it. And if the developer is not forthcoming, I think the lawyers are here too. And the arbitrators, they come in the middle of everybody so that we can all sort it out amicably. We don't have to go through a lot because it's realistic. Cement going from 2005 to 4005. Now we are talking 12,000 naira per bag. So it's a difficult project out there. As I said earlier, we are taking the bullet for you. What we build for you for 50 million, you might not be able to achieve it if you spend 65. So that is where we come in, because most of our things, we price them in bulk. We do a lot of things in bulk. So we'll be able to achieve some of these things and beat the prices on your behalf.
Thank you,
know.
Sorry. I know that we are time conscious, but can I throw in 10, 20 seconds to that, just to add to what he said? I also want us not to rush into, let's not say because a property looks affordable, then we just rush in. Do your due diligence well. Look at the property you're buying into, look at the brand you are buying into. The company is very important. Look at the track history. Have they delivered? Do they have a history of not completing projects? So those are things that I also think as lawyers, we should also be very, some developers tell you are difficult, be difficult, but do your due diligence to the core and make sure that you dot your I's and you cross your T's.
Thank you very much. It has been it's very insightful.
Yes, it is. But I raised up my hand the other time that I want to ask a question, but I have to indulge our members, and I want to crave the indulgence of the faculty, because the beauty of any panel session is to have a feedback from the people that you have spoken to. That feedback, rubber stamp, your panel session has been engaging, and indeed, I want us to please indulge these two individuals, Grace Ajayi and one law school student put up. Who is the person again? Okay, please, I will indulge you to do your own first. I will round it up, because it's important that they learn from the source, now that you are here.
Thank you very much. Okay, so my question, I wrote it down. You highlighted the merit of the mortgage system. So, well, how feasible is a mortgage plan in Nigeria, considering the constant fluctuations in the value of the currency and the economy? Thank you.
That question is actually for Mr. Daniel. So please.
Thank you. Okay. Currently, the Ministry of Finance is running a mortgage system termed Mr. MREIF. REF, yes, at 9.75% interest for 20 years. So, and in as much as it's been done now, it has been done before, 2018 and then 2016. 2016 in Lagos, and a federal mortgage system owned to rent by the federal government too, both Lagos and at the federal level. So it's very feasible, right? It's currently being run, although it's still a new initiative. It's not still widespread, but we believe that, the expansion is taking place, and of course, so many of us developers will tap into it, and then of course, property for everybody to buy at that level. So yes, it's very feasible in Nigeria.
Okay, just also to make a comment with respect to your question, because I understand you are directly talking about the exchange rate, right? So I think that it's not within any control. It's not within the control of the developers or the buyers. The most important thing is you find how to hedge your fund. If you are able to hedge your fund, you may escape the liability that will come from it. Thank you. So I'll miss Madam Grace to speak.
Okay, thank you, Chairman, for indulging me. Good evening. What a wonderful panel session. My question is directed to the developers, and it's a practical question, and it has to do with the refund policy of real estate companies. They all have this refund policy that when you want your money back after paying, there is a certain amount that is being deducted and all of that. I want to know the rationale behind it. I know they'll say they've paid the agent that brought them, they carried out some development, but that same property that the person is withdrawing from will still be sold to another person, and you will still collect all these charges from this person. And most times when people ask for refund, it's not because, most times it's because the real estate is delaying, or there is one issue or the other. So what is the real true rationale behind that stuff. Thank you.
Emeke seems to be excited about the question. You want to answer?
I am excited. You might not go down well with the rest of my developers, but I told you when I started talking that we're a future forward-thinking company. And I can proudly say that we don't do that in my company. Yes. So if you make payments and you come back 6 months down the line and you say, well, I don't want to buy again, give me my money back, we'll gladly give you your money back. And the reason we do that is because we understand valuation on our properties, right? A land we're probably selling for 300 million. By the time you're coming back, it's probably way higher than that. So we know that we'll sell our land back, and we try to always be transparent at Metro Speed. So it's not one cap fits all. We don't do that.
Okay, turn answer.
Thank you for the privilege. So my question is going to the regulators of the industry. Unfortunately, the other 2 or 3 key players that we are expecting here were not able to come. We have the Ministry of Environment, headed by one of our very finest learned friend in person of Tokunbo Wahab. And we actually expected the PS land in person of Mr. Alajolo Shago, and also the Surveyor General and Mr. Aboyeji of the NTDA. We were hoping to receive all of them, but unfortunately they are not here. So my question is this. In a situation whereby the regulators are the one helping those who want to commit fraud in the industry by indulging them to do some things that would jeopardize the interests of the investors, how do we curb that, or what can the institution do in reversing that? I have a very serious scenario to buttress that. One of our sponsors for this event purchased a land of about 1.something billion naira from Ibejuleki. After buying the land, they carried out their due diligence. We ascertained that the land is within a certain global CFO of a particular location. We went to Eti-Osa to do the due diligence. We went to the Surveyor General's office to chart the survey. Everything was good. And on that strength of representation, they started selling to third party. Only for the third party that bought the land to now go back to that same Eti-Osa to go and conduct search, and they now discover that the title has shifted. As at the time they sold, the title covered up to this place, and as at the time they resold to third-party interest, the title has moved from here, beyond here, and now got to this place. So the entire stretch of land that this particular investor bought was not covered by any title again. So how it happened that they went to Eti-Osa to do the deed of rectification, to ascertain all of that transaction, still baffles us till today. So what can the regulators do in curbing all of this? Because there are hands of some pharaoh in the system that will go in there, exchange those documents, and make such thing happen. So it happens on many occasions, and is a critical issue that we want them to address, and probably go back to the ministry and see how they can sanitize the system to ameliorate all of this problem.
Very beautiful question from
and on the last note, we are saying this to our players of the industry, that there is a new remuneration order that has been passed by Nigerian Bar Association at the national level. This was made law in 2023, March 2023, order 10, by under the leadership of YC Mikiao, that any of our transaction, that is transferring interest in land, is no longer the usual way of saying, is it not just ordinary paper that you are typing, is 1% and paying, is 2% and paying. The standard practice now is 10%. And in Lagos State, all the MBA branches has come together to pass a resolution to that effect, and any lawyer that run foul of that will definitely be sanctioned. We refer them to the disciplinary committee. So please help us to help your in-house lawyers not to run foul of such regulation. If you carry deed of assignment to them to stamp and put their seal and append their signature and be giving them maybe 50,000 documentation, you are preparing them for expulsion from the practice. We want this to stop, and Lagos, as a body of MBA, we have come to understand that, and we are praying the regulators, the players, to please work along with us. When you see lawyers that has bow leg because the shoe has bended, it's because of that kind of practice that you sell property for 100 million and you will be paying lawyer 1 million naira for a transaction of 100 million. So please help us to live the life of what we are doing. In outside the world, nobody contests with lawyer's fee. You pay it ahead of any transaction. When you want to buy property in Canada, America, you pay into the account of the lawyer from where the money will be sourced to the bank of the seller. So we want to implement such so that we will look good and do wonderful things in this profession. Thank you.
Thank you very much, Chairman, for the contribution.
Thank you. Even though I'm not from the ministry responsible for documentation, which would be Lands Bureau, but going back to what I had said earlier, the information you get out of any particular system is only as good as the information that was put in the first place. Then in addition to that, my co-panelist has said here, Lagos State is going digital. Where that can be done in the totality, I think such things would be minimized based on people giving the right information at the first instance. So it's twofold. People giving information that is right and correct and a true reflection of what is on ground, and then going digital to minimize the human handprint, human interaction, because once it's in the system, it will minimize people doing strange things. But the caveat there is that is what is inside that can only be brought out. Thank you.
Thank you very much, ma. I can see from the face of the chairman that he has more questions for you after this section. But I sincerely want to appreciate the panelists. Emike, thank you so much for coming. Daniel, thank you for coming. Thank you for the insights that you've brought. Prince Ogunbowale, thank you. Mrs. Olorufemi, thank you so much. Just to run through the points that have been made, issues of flooding, we have a responsibility as residents to keep our environment safe. It's not just on the part of the government. And we also plead with the government to please look into the issues of flooding in Lagos State. And we appreciate what the Ministry of Environment and Water Resources are doing currently. Please extend our regards and commendation to Honorable Commissioner Mr. Tokunbo Wahab. And then also compliance, we should ensure that before you start setting up any estate, ensure that you comply with all the regulations, environmental impact assessment, drainage issues, setbacks, ensure that you are in compliance. And also, we also want to plead with the government, can we have policy certainty?
So we say we need smarter systems and smarter chairs. Chairman, please, next time, let's get smarter chairs.
Chairman has denied the chairs. It's not the property of the Nigerian Bar Association, Eti-Osa branch. Thank you very much, Chairman. So policy change, we should ensure The government should please ensure that there is certainty with respect to policies and not just change them. Smart approvals, integration of AI into the system, and smart chairs too. Digitalized verification, and we should build homes that would attract our brothers and sisters abroad. We are missing them. We need them home. Thank you very much, everyone. Thank you for your contribution. Thank you for listening.
You can do better, please. I believe one thing we have been able to establish from this session is that we have people ready to collect your money. We have the regulator who is ready to collect your money in taxes and fees and also penalty for defaults. And we have the developers ready to collect your money from purchase of buildings and other things. Well, let us not talk about that. So we appreciate the panel, and we would like to take pictures with the panel before they leave. So, Mr. Chairman, the Chairman Planning Committee, Mr. Banji Alabi. So after the picture session, the Chairman of the Planning Committee, Mr. Banji Alabi, would give a vote of thanks. This is also to remind everyone that we have dinner tickets for tomorrow's dinner. Just walk outside of the hall, you'd see the person selling the tickets.
Everybody, please come. Today is the last day in Oriental. Please have not taken photographs in Oriental.
The sessions for tomorrow will be at the Naval Dockyard, Victoria Island. And it shall be on legal tech, emerging firms, and also the black tie dinner. From 10 a.m. prompt. We are starting on the dot of 10. Mr. Banji, give the kindly sit for the vote of thanks.
Well, on behalf of my chairman, OBD, members of the planning committee, and the entire members of Eti-Osa, I'd like to thank our panelists for finding time to come here despite their very, very tight schedule. Thank you so much, and God bless you all.
No. Distinguished ladies and gentlemen, today has been a day of ideas.
Please, all the students of law school, kindly come out. Come and take a shot with me, please. All the students from law school, please come.
Yes. While the photograph is going on, today is a day well spent, a day of insight, a day of challenge, a day of possibility. We began with arbitration. We journeyed through legal education. We concluded with real estate and economic opportunity. Yet beneath all of these conversations runs a common thread. The future of justice, the future of legal practice, the future of our nation. As we leave this venue, may we leave not merely informed, but transformed. Not merely inspired, but committed. Committed to building institutions, committed to creating value, committed to leaving the profession stronger than we found it. Because ultimately, the law is not just what we practice, it is what we contribute to society. Thank you for being part of this remarkable day. May God bless the Nigerian Bar Association. May God bless MBA Eti-Osa branch. May God bless all of you. And may God take you to your various destinations. Thank you once again for attending today's session. We have packages for everyone just outside of the gate. Yes. The session for tomorrow starts 10 on the dot at Naval Dockyard. 10 of the, yes. Naval Dockyard. Naval Dockyard, not Orientals, please. 10 on the dot. Ensure to be present on time. It's going to be, we are going to have sessions for legal technology, for emerging law firms, and also the dinner in the evening. You did well, sir. We also wish Mr. Oriolua Atijon a happy birthday. If he's here, let him come forward. Atijon.